No, no, no.
Fresh admission. What next week? Next week. Put all next week. Take all matters next week.
This is judicial order. There is judicial order.
No, because I have wasted your time. Then waste more time. Yes.
It's a matrimonial.
Do that. Next.
This is a matrimonial list specifically fixed to today. There's not
Come
come.
next.
Tomorrow the similar 2 matters.
That's it.
My lord, take it.
Yes.
Warrant to mention my one.
Next.
My lord.
Lordship, this matter, I have filed mention memo on 12th August. Direct to list this week, but not list.
Next. Yeah.
Termination matter, my lord.
Yes. Take next.
To termination matter, my lord.
Just
Madam, this is a matter.
Yeah.
The admission to the BEd course today is last day, madam. Two date fixed. One is 30th of August, another is 1st of September. 30th August was madam holiday. That was 30th August.
Afternoon.
2 days, madam. 2 days.
Afternoon.
Afternoon.
Warrant to mention, my lord.
Yes.
This is about educational hostel matter, my
Yes.
lord. It was posted after 3 weeks. The urgency is that 500 children have already been given.
Give it.
Please, madam. Let it be taken
I know
care
that.
of.
Advocate General had appeared in that matter, na?
My lord.
Same matter. I know that. Next week. Yes.
Retired since 2017, my lord. Regarding pension, my lord.
Week after. Yes. Don't waste time.
Cascade correction. I want to mention was after notice matter.
You notice matter. 2 weeks.
Next matter relating to examination.
Examination. When examinations are set?
PG first semester, madam. It
When?
It was before Lordship board, but did not reach that.
Not a pitch. Next one day. Okay.
Whatever security deposit, my lord. Notice has been issued, my lord.
Yeah, for the 2 weeks.
Item be mentioned, my lord.
Yes.
Item 49.
49.
Yes, ma'am.
You want time in that?
After from Madam Jenna, that I have taken off day off tomorrow. Sunday morning was.
No, you can ask time, but don't say when it should be taken. Only due time, not stay. 49, na?
Yes, ma'am.
2024 matter after 2 weeks. That's the request now.
That's item 52.
52.
My lord.
Yes, brother.
That may be taken up after 2 weeks.
All 3 weeks. That's the request now.
Item number 10. This has been wrongly coming before this board.
10.
The revenue matter.
To be posted before the roster bench after verification of records. Okay.
My list item 61.
61.
Kindly take up this matter next week, my lord, sir. File agenda.
Which year, matter, brother? 25. The week of.
61.
That's the request now.
Item 64.
64.
64. Take 2 times
Ah,
for
really?
counter.
Item 13. That's the request.
Item 13.
1-3.
2 weeks ago.
2 weeks. This I have already, once it had come now, actually. Anyway, 3 weeks, 4 weeks. That's the request now. Yes. Yes, sir.
Item 1.
I have already submitted.
Find your written reply.
Yes.
Okay.
Today.
Yes, shortly. These 4 days I could not work because of holidays, vacation, festival. I will do it at earliest. Yes.
Item 1.
May I please your lordship, my lord,
Yes, sir.
that the humble petitioner, being a scheduled caste lady,
You take notice.
my lord, only my prayer, the pension of head annexed for may kindly be disposed of, my lord.
My lord, this is purely civil in nature.
But you tell that in writing. You can send that reply. Okay. Short grievance of the petitioner is as to non-consideration of the representation. Dated so and so at annexure. What is that annexure, brother? You
Annexure
have not
4.
written annexure in your prayer.
Annexure 4.
Annexure 4.
4 minus. Page 47.
First off, learned counsel for the petitioner permits that non-consideration of representation of the citizen. It does not augur well to the constitutional jurisprudence of the country in view of Article 350 of 350. First, there is force in this submission. Next paragraph. Learned AG appearing on request appearing for the opposes the petition contending that matter involves civil dispute and therefore should be worked out before the civil court in the light of expedition in Dhulabai versus State of Limit. AR 69 Supreme Court page 74. Okay, 78 perhaps. Just first. Next paragraph. having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in as much as non-consideration of the representation of the citizen would cause enormous injustice when their redressal is not granted. First of all, this accords with the reasoning on which Article 350 of the Constitution is founded. First of all, in view of the above, the petition is disposed of, giving a period of 4 weeks for considering the subject representation in accordance with law, and also to inform result of such consideration to the petitioner. First of all, conditions are kept open. It is open to the answering respondent to solicit information. So,
May I submit one thing? The mode of communication is not there.
That's not. Anyway, now we have got it. Kerala High Court said late last week, there need not be separate representation at all. Petition should be treated as representation.
My lord, your lordship may say that. Otherwise,
one more sentence we can add. Petitioner is permitted to serve one more copy of the representation along with vouching documents in support of his claim. First up.
Item 2.
Yes, next.
The petition challenged the illegal and unauthorized construction carried out by one Hosea Builder Private Limited.
Yes.
On the basis of fraud and fraud.
You appeal
and
for
fraud.
The Cuttack Development Authority, my lord, such a limited role.
that role you have to play.
It's a limited that role we have falsely played, my lord. Fact remains, I will only point out one thing: we are filing counter for my lord's result today. My lord itself we are filing.
But no, this is when notice was issued.
Notice was issued. My lord, last time
2 weeks
today.
for issuance of counter.
My lord,
Dealing with
my lord, another thing is
nothing
that
will happen. Is
my lord, in this
2004 and 5, my lord's
nothing will happen. No heavens are going to follow. Yes, next.
no, my lord, yes, here in
Our private opposite parties.
Sir, my lord, sir, I am coming to that point, my lord. There are in this petition, there are 6 to 7 private parties. My appeal is that I may request to that to issue the notice to private parties, all the private parties. And here, so my lord, one Cuttack Municipal Corporation plays a vital role. They should be directed to submit their counter with a videography of the
I can't direct all that. Let me file the objections. Next.
all the private parties.
Yeah.
Item 3.
Yes, next.
Regarding refund of a security deposit, the security deposit was deposited for operational route. My lord, the earlier passed order in the similar type of matter, my lord.
Identical matter.
Similar matter.
It is already.
Issue notice.
Issue notice. Call along with the WP number. So what? Next.
Item 4.
No, item 4 pension matter. Your lordship is to third week of September.
Similar matters.
Madam, the notice issued.
Notice will be sub notice for AGA for whom?
1 and 2.
1 and 2. Private party?
Private 3 is
There
there.
are private parties?
3 is there.
But no issue. 3. Next.
4, 5,
Call
12,
along with WP number. So
4, 5, 12 and 15, 7.
4, 5, 12 and
15.
5, 12 and 15. Call along with WP. Okay.
6 also same, my lord.
Same.
Same. Private opportunity, OP number 3 and 4.
3 and 4. 1 and 2 each. Yes. Call along with.
Item 6. 6 also
Same back with
Huh?
6 Golab.
It's also same.
Yes.
Yeah, 6 is over now.
Item 7.
Yeah.
Item 7, my lord, I am placing on behalf of Mr. Naik. Here, my lord, I am challenging the order of rejection where release of salary in favor of 4 PM. Similar matter, my lord, have already issued notice. I have given that.
Emergent notice, AGA for all this
My
one.
lord, my lord.
All this.
These are the all similar matters.
Yes. Call along with WP number. Yes.
Item 8. In this case, the petitioner challenges.
Kindly be little louder.
The petitioner challenges the order at Annexure 2, my lord, directing the petitioner to deposit an amount of 8,94,407 rupees, alleging that there is a erroneous pay in
What was the designation of your client?
My lord, that is a retired primary school teacher, my lord.
Primary school teacher.
My lord. Here
But
also-
it does not fit into Rafiq Masid class 3.
No.
Will not fit into class 3.
The second provision of Masik
No,
retired employee, my lord.
not retired, not all retired. Suppose if IAS officer is retired, so only class 3, category 3, group 3. We have clarified it also in another judgment, myself and the brothers house of. Did you give, have they given notice to you?
No, my lord, nothing. They have direct me to deposit the amount for resubmission of my.
My lord, control of accounts. They have
Can you directly direct them?
My lord,
Treat this order as show cause notice, let him show cause, and then you can take the action. Just examine, have you taken up that contention? That no opportunity was given to you.
my lord, what I submit, my lord, opposite party number 5, control of accounts, they have raised the objections.
Correct.
They have separate councils. What I submit, my lords, that notice go so that they appear.
Then don't recover till then. Issue emergent notice. Learned AG is requested lots of notice for 1 and 2.
1 to 4.
1 to 4. Panel counsel, who is that general? Panel.
There is no separate panel of the control of
Issue emergent notice to the
accountant general is the separate panel. The state government can appeal for the control of accounts.
So then retired employee, and therefore in the evening of his life he cannot be put to prejudice during the pendency of the petition. First of the apex court in Bhupendranath Hazarika versus State of Assam 2013 so and so has held that the state has to conduct itself as model employer, and that requires that the petitioner should have some reprieve at the hands of this court during the pendency of this petition. First, next, in view of the above, the impugned order of recovery is kept at a suspended animation till next date of hearing. Yes.
Item 9. Discuss, my lord, this matter is covered as per
This
the
order is issued in the light of and traffic mercy, which needs to be deeply examined. Yes.
May I hearing this matter is covered as for the decision by Annex of 7 at page 20, which has been passed by this honorable court, my lord. To that extent, I want to draw attention this petition was appointed on a contractual basis.
Let him examine.
Yes, that is I should this one. So that can be disposed of, keeping in view the decision which is already made by this honorable court.
To consider.
Yes, my lord, right, keeping in view the
Where is your
Annex of 7, my lord.
correct 7 is judgment. Where is your representation?
No presentation I have made, but this is the decision which I have enclosed.
But how
Similar.
Who seeks? Why these fundamentals? I should not say much about that.
Annex 3 is the representation.
That to be considered.
Let it be considered. Keeping in view the Annex of 7, my lord, which is a decision made by this honorable court.
To Annex 7.
Much
Justice Satpathi's judgment.
much obliged to that extent.
Short grievance of the petitioner is aired in the representation dated Annex 3. First off, counsel for the petitioner submits that in view of coordinate judgment
Annex of 7.
judgment
Page 20, Annex of 7.
dated 22/3/2023. A copy in WP numbers 2062, etc. of 2017 between Biplab Kumar Sahu versus State of Odisha and others disposed of on 22/3/2023, the representation ought to have been considered, and the benefit granted to other similarly circumstanced persons ought to have been extended. First, counsel adds that this having not been done, here the client has no alternative than to knock at the doors of this court. First up. Next paragraph. Learned AGA on request appearing for the respondents opposed the petition, and he also sought for time to file the objections. First up. However, having opposed the petition, now fairly agrees with the suggestion of this court that the petitioner's representation at Annex 3.
Annex 8, my lord.
Annex 8.
8, page 26.
Annex 8.
8, my lord.
Yes,
Dated
dated
26.
4/12/2024 needs to be considered at the hands of answering OP. First off, he also puts a rider that all contentions of the party should be kept open. First off, petitioner is agreeable. Counsel for the petitioner is agreeable with this proposition. Next paragraph. In view of the above, the petition is disposed of. a direction issued, the writ of mandamus issues to consider the subject representation at an executive within a period of 8 weeks, which will include solicit information, all grounds.
With your lordship's permission.
Okay.
With your lordship subject to acceptance, my lord, to that extent, keeping in view the Annexure 7 with your
In the
lordship.
light of the coordinate pen decision at Annexure 7.
Not obliged to that extent.
Okay.
Item 11.
Times to be so, my lord.
8 weeks. 8 weeks.
Much obliged to that
All
extent.
right. Yes.
May please your lordship. My lord, I am petitioner. Petitioner challenged the illegal action of the opposite party number 3 DO Jashpur, my lord, who did not grant the salary from 1 February 2019 to 26 February.
1 to 2019 to 26 to 2020.
Yes, my lord.
Why they did not give? Did you perform your duty?
My lord, Annexure 7, page number 29, my lord. My grievance representation.
This is in a Brahmi Lipi. I cannot read at all. You have not put a typed copy.
Oh, no, my lord.
What you have said in this? The above circumstances, I pray.
Representation of the year 23.
For the above said period as soon as possible for which check signed. So you said they have given a representation. Well, that representation is rejected.
Representation of the year 2023.
All right.
States.
So now,
File a fresh representation.
but this court is being used for consideration orders. I don't understand really. I am against giving any direction for consideration. That means you will reject and again they will be driven to this court. Where is the assurance to the court that whenever you have sent us for consideration, we have done justice to the litigants?
There is no proof whether he has filed the representation. There is no proof.
Do you have got any proof in your document? How you have served that copy? You don't have. You give one such matter now, so that they will never raise that objection hereafter. I will do that way. Okay? You have issue notice.
Better file a fresh representation.
Fresh.
Then you.
Why fresh? Where is the assurance to the court? Sir, you have directed consideration. In about 100 cases, you have done that. We have given justice to 12 people. These are our orders. Why citizen should be driven to court to consider the representation? I do not understand. That kind of justice I will never do. That is unbecoming of a judge. Where is the consideration? In one matter, give me one sample. Again, sending her back and for rejection order, one more repetition. Only bar will be reached and a judge will be enriched in terms of disposal. But what is the use to the citizen? That is not the object for which this court is established. This court is established not for maintaining carries. It is established to ensure rendering of justice to the litigant. Otherwise, they will not have respect for the judges, respect for the institution. They start treating the judiciary as government is treating it now. No, sir, this I don't agree. I am dead against giving direction for consideration. That will not help them at all. It only adds to my CV, but I am not aspirant for anything.
Issue notice.
Issue notice. Issue emergent notice. Let me requested or sub notice for the respondent. What should be done?
My lord, so what happens in last case, there was a delay of 14 years. They come here,
You can
file one representation.
Extreme cases we understand. But after I came here on May 12th,
My lord.
I have not been shown one order where justice is given to them. One single sample order is not given to me, not shown to me.
They get yes cause of action by way of
Then what all poor people, what they should do? They are coming with peon, teachers, FDCs, SDCs. If they ask to spend time, their money, what opinion they will have about the judiciary? They think that judiciary is meant for only rich people, not for us. That impression we should never give. At least I don't want to give that impression. At least a few judgment decisions you show me, so that I will have confidence in the government. I am yet to form my confidence in the government. Really, I do not have confidence. I, as a judge of the High Court, do not have confidence in the government. Let people see my video. Let them see my video. Let them see what government is doing. The short grievance of the petitioner is as to non-consideration of the representation dated 27 February 2020, wherein he or she,
Yes, ma'am.
She has sought for regularization of her service and also for release of alleged withheld salary during the period between 1 February 2019 and 26 February 2020. That is 391 days in all. First off, learned counsel appeared when the citizen gives a representation, the model state is bound to consider and grant redressal to the same within a reasonable time. First off, this having not happened, the petitioner is grieving before the writ court. First off, learned government advocate, the AGA, appearing for the OPs on request, having opposed the petition for some time, now submits that the representation is too old and that no proof is produced, no evidence is produced to prove that it was submitted to the jurisdictional OPs, and therefore, if the petitioner gives one more representation, the same shall be considered within a reasonable time and in accordance with law. First off, he puts a caveat that court should reserve all contentions of the parties. First off, with this, when counsel for the petitioner is agreeable, first off, in the petition is disposed of, with the liberty to the petitioner to make a representation of the kind at an exact
7. Annex of 7, page
an exact 7. Date will be changed. Date you have to see 28/12/58. Not an exact 7. First off, if such a representation is given, the same shall be considered by the jurisdictional OPs within an outer limit of 8 weeks, and the result of consideration shall be made known to the petitioner in writing. First, all contentions of the parties are left open. Next paragraph. Open to solicit, no course. Now, no course. Yeah.
Item 14.
Item 13 is similar to item 12. That is
13 is already notice issued. 14 it is now. Yes, sir.
Case relates to antedated regularization, identical matter your lordship has issued notice.
Issue emergent notice. I go by your words because I don't doubt lawyers. No, I'm telling you. I have no reason to doubt lawyers. Yes. Issue emergent notice. AG is requested.
3 and 4.
3 and 4 advocate.
3 and 4. Emergent notice to 1 and you appear for 1 and 2 size. Say signed. So that's on request.
I've received the copy, my lord.
Yes. Accepts notice for
Time order may be passed, my name is.
Next paragraph. Learned counsel for the petitioner presses for the interim relief.
No interim relief. No.
But why are you passing it to me?
No, only this is identical matter your lordship has passed, not for that reason.
Call along with WP numbers. Yes.
Item 21 also same, your lordship.
21 also same.
My lord.
Oh.
Item 16.
Yes, sir. Yes, sir.
Villagers are before my lord.
Villagers are before the court.
Because the road, which is a public road, has been blocked by some antisocials.
But this matter should go to the...
No, any other item, not
division bench, PI.
No, it is not.
They have right of way.
It is
They
not.
have individual right of way.
It is the right because the villagers are unable to pass through because the antisocials have blocked the road. They have approached the collector, sub-collector, BDO, Tahsildar, nobody has had.
Nothing.
Nothing. The representation is on annex. My lord, can we see the page number 9? How the brick walls has been constructed over the road.
You accept notice and tell next week?
Yes.
No. AG issue emergent notice. AG is requested to accept notice for the OPs. All OPs. First off, all OPs. Call this matter next week. Since the ingress and egress is blocked, allegedly blocked to the villagers, which is not a happy thing to happen in a governance bound by rule of law. First off, call next week. Yes.
Item 17.
May business. Yes, sir. In this case, my lord, the petitioner is a demonstrator. He wants the pay fixation in a particular rate, what it has been given to the other demonstrator of the other university. It has been given other university. You see, I'm in a university, the Sambalpur University. University to university. No, that is a state universities. It is government. Yes, same state, same act. Under their universities are established in the same act. Same act, 1989 Act. 89 Act. That is the act, man. So now, which university is yours? I am in Sambalpur University. Which are other universities established under the same act? The 15 university of the state. All the yes. That is called the state universities. Any representation of the yes, representation is there, and in pursuant to that representation also, just before I was hearing my lord, page 19 is my representation. They have duly received. And moreover, the university has recommended to the government in Annexure 6, page 95, 24. Mine. And this page 25, Annexure 6, may kindly be seen. Take notice. University has recommended to the government because they want a clarification from the government on this issue. But government will sleep over that. That is the 24. That is also same issue, emergent notice. DG requested to notice for
One.
one. Yes, wait, emergent notice to the rest. Yes. If my lord will direct the state to take a decision in light of that, it will be because of sufficient. Are you going? They cannot go beyond because their own action. But notice to others will dispense. You file a memo deleting them. The university has recommended my case by the formal party. The university has recommended my case. Mr. Dash, why can't you read heir 1958? So yes, yes, I know, but dispensing will still you want to say. He only say in this purpose, my lord. If the finance part will come, the grievance of the petitioner is reflected in the prayer column of the petition, which reads as such. Next paragraph. Learned counsel appearing for the petitioner draws attention of the court to your representation dated annexed, that is 9/7/24. 9/7/2024 at Annexure 4 series, wherein a decision has to be taken by the first respondent official state in terms of recommendation. Where is that? Annexure 6, page 25. Recommendation. Of the university.
Beg your pardon. Annexure 4, that is representation addressed to the vice chancellor.
Yes, the vice chancellor has sent government recommended his case for grant. What do you in terms of university's representation dated 20 September 2024 at Annexure 6. This is a communication to me stating that government have been moved. Last line. No, government is also a partner, Department of Life Science, Sambalpur University. No. I am there. This is a communication to me with a reference to that last paragraph may kindly be seen, madam. Further, your claim, the above claim have been considered after receipt of the clarification government. That is the point. Learned counsel for the petitioner draws attention of the court to the university's letter dated 20 September 2024 at Annexure 6, wherein the registrar of the university has informed the petitioner that the decision in principle has to be taken by the government. And if the government takes the decision, things will be set right. First, therefore, counsel submits, that the government should be mandamus to consider request of the petitioner as has been reflected in the subject representations. Though they are addressed principally in the name of the chancellor, of the vice chancellor of the university. First, next paragraph. Learned AG on request appearing for the respondent usually registers the petition of the time, contending that there is no proof that any representation is given to the government, semicolon. Annexure 6 document of September 2024 is only interdepartment, is a communication between the university and the petitioner. And therefore, unless there is a demand for the discharge of the public duty, petition of the kind is not maintainable. First, having so contended, now he graciously agrees to advise his client to look into the grievance of the petitioner in the light of her representation, his representations at Annexure 4 series and also keeping in view the University Registrar's letter dated 20 September 2024 at Annexure 6 in accordance with law and within a reasonable time. First off, he puts a rider that all contentions of the parties be kept open. First off, he also tells that if the petitioner gives a comprehensive representation, that would become handy for the government to consider the same. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a comprehensive representation to all the respondents within 2 weeks with the vouching material. And if one is made, the same shall be met with due consideration at the hands of first respondent in accordance with law within an outer limit of 8, which will include intimating the result of such consideration to the petitioner. All contentions are kept open to solicitation documents. Now, no course. I am putting now no course because next time there will be course, only for the reason. Yes.
Item 18. Actually, the order of rejection, it is 11/7/2025. The paid for anti promotion. Identical cases and my lords have issued notice. Annexure 17, the rejection order.
Issue emergent notice. AGA is requested to accept notice for all respondents.
Yes.
All respondents. First of call this matter along with WP number.
Hello?
Any connected matters?
Connected matter.
Yes, I have to call out. You have that? Do you know? Not yet. Can you furnish?
Yes.
All right. Along with WP number, so and so. Okay.
Next it will same.
Same. Yeah.
Item 20.
Yes.
It's the second round of litigation. Earlier, the petitioner approached this honorable court for non-consideration of his claim for regularization of the service. That is, this honorable court
We have issued notice in similar matters.
No.
No, this is different matter. What is your right to consider regularization? How many years of service you have put in?
Lordship, since 1993, I have been
93?
93.
You have been working since 93.
91, I have been working. In the first case is in the year 1993 before the tribunal. And then after remand from the Honorable Supreme Court, the matter was remanded to the tribunal. Tribunal disposed of the matter in the year 2012 and directing that there has been committee constituting of the members that whether all the petitioner who has been continuing in service, they have to be regularized. Despite the
that they have not done.
No.
But one more petition, one more order we will make, they will not obey that order.
No, Lordship. I have earlier approached. This honorable court disposed of the matter, directing to take a decision. Pursuant to the direction of this honorable court, they have rejected that. I am challenged.
It requires consideration. Issue notice. AG is requested to accept notice. Since matter requires deeper examination, this petition being the third round of litigation. All right. Call in the third week of September.
I humbly pray, Lordship, OP 1 to 4 being represented by the state. I have to take extra. 1 to 4. Only 5 I have to take notice.
5 is
5 is the governing.
Legible copy of Annexure 17 may be supplied.
You give full set of copies.
My Lord, I will, sir.
Item 22.
Yes, brother.
My lord, the petition is now within junior clerk, but he was given some benefit under Annexure 3, your lordship kindly.
Now what happened?
In 2017, from 1/5 to 15 years, given a RSCP of grade pay of 4,200, my lord. Now, you will continue with that.
Mr. Murthy, we have issued notice similar matters.
Similar matter notice was issued and date was fixed.
My lord, that is not
Different. Then it is notice we issued that too.
On the sub-notice for the respondent.
interim stay for recovery.
We have given a stay in other matters. We have given stay
in some because this is a different issue altogether.
NSR 7, your lordship, and 5, 6, and 7.
It is issued at the interim stay
Annexure 6 and 7.
At of Annexure 6 and 7 till next date of hearing.
Agree.
Since matter merits deeper consideration.
Item 23.
Yes, sir.
No, this is a case of denial of promotion, madam. They are not taking, if you not kindly come to page 63.
To consider your representation.
No, but, that will not solve the purpose.
But you have to make the prayer. What should I do?
Only one thing, page 63.
No, that's all right. But your prayer is to consider.
Because, my lord, they are captioned, my lord, 4 subjects.
That's all right.
Page 63, no, kindly have an answer. Why I am saying, my lord? Page
63, have you kept any Rasgulla there?
No, only one thing, if you also kindly see serial number 4. This is post of, my lord, TGT SST. Yes. Be inputted, my lord, PGT history, geography, economics, political science, sociology. They are so far not considered, my lord, economics. That is why, my lord, I have given in prayer, because my juniors have been promoted.
Correct, but that will be a policy matter.
No, I am not challenging that policy. Within that bracket, my lord, I am also entitled to be considered.
In that policy, you are not falling.
I am following even that.
What is your specialization?
My specialization, my lord, is if you also look at my representation, I have
I am asking you.
My lord, TGT
Maths.
and TGT science.
It is covered under that only.
Yes.
In the last 7 years, nothing has been done.
No, they are not taking up this that category of TGT. So that's why I have given a representation.
Take notice because what representation this my order will have, I don't know.
Trained graduate teachers and postgraduate. So far, the comparison is concerned at page 63. The TGT SST, social studies, and PGT history, geography, economics. So it needs a counter. And so far, the representation is concerned, it is at Annexure 6 as page 84. My lord has rightly pointed out that so far the representation is concerned.
Last but one paragraph, I have clearly.
Let them consider the representation because on merit.
Or if they want to finalize the case, then notice be issued, we will come prepared with a counter. Either of the
consider the representation, he is agreeable. Now he has given
you will be disposed of. Because by this time already 7 years elapsed.
The grievance of the petitioner is as to non-consideration of his promotion to the next level. Though, according to learned counsel, the case of the petitioner fits into the policy parameters. First up, learned counsel for the petitioner submits that in connection with the grievance, petitioner has already made a representation dated 4/4/2025, a copy whereof avails at Annexure 6, and no decision is yet taken, nor there is any hope that any decision would be taken in the near future. And therefore, this court should intervene. First up, learned AG appearing for Mr. Monti appearing for the respondent supposes the petition contained in that unless right to consideration is demonstrated, this court should not readily grant interference in matters like ended. Now he fairly agrees with the proposal of this court that the subject representation should meet its consideration at the hands of which OP?
That is, the opposite party number 2, Mera.
OP number 2?
Yes.
OP number 2 in accordance with law and in a time-bound way. First up, he enters a caveat that all grounds should be kept open. First up, with this proposal, petitioner's counsel is agreeable. Next paragraph, in view of the above, petition is disposed of. Fixing a period of 8 weeks for consideration of the representation and communicating result thereof the petitioner, all contentions having been kept open. First up, open to solid seal. No course.
I mean, I don't know. 6 and 7 is related to the fixation and recovery matter. That's what mentioned to recover.
They are directing you to pay. They have sessioned you to recover.
Yes, the 7 manner and 6 recovery. They have already made order.
They have said that if excess amount so paid will be recovered. That was the language.
Already recovered. And settlement, calculation sheet they have given.
This is liable
They have
to be
recovered
recovered.
already.
Liable,
To recover,
Miller,
my lord, not started.
this is liable to be recovered and it's a order dated 23/7/2025.
28/7 is just 1 month.
1 month just.
That
Whether it has been recovered
How
or
many years of service you have got it?
My lord, I am 94. I was appointed. 15 they have given me any benefit. Now 25 they have noticed to recover the amount.
What is my question? What is my question?
How many years of service? My lord?
Left over.
I appointed in 94. My lord.
Not so. It does not, your service does not depend upon the year of appointment, depends upon your age. Birth date, if you give me, I can just have. Suppose if you take money and go, well, what should the government do subsequent? Therefore, if you have got more service, we can say.
as per the cost title affidavit, now he is at the age of 52.
52.
As per the affidavit.
Therefore, even if we take that it is 53, 54, still.
I mean, they are 6 years.
Therefore, we can rest, we don't recover. He will not run away. 6 years he will be at your hands only. Any notice issued already?
Here notice was issued.
Yeah, stays, we should stay also.
6 and 7, relative recovery and refixation. My lord.
You said annexures 4,
6 and
7 you said. We have stayed it. Stay of recovery pursuant to impugned orders at annexures so and so till next date of hearing.
My senior is in hallucinations that possibly relief was more by this court.
Yes. Yes.
Here, my lord, is a case of reconsideration, my lord, position in the gradation list. I am a BA graduate.
Where you should have been. Gradation list.
In the, my lord, in the lower category, my lord, they have been placed. IA category.
No. What's your gradation?
Gradation, my lord, if you also look at page 16, it is 383.
And 2, 3, 4? They are the authorities who have to do.
So what have happened, my lord, in the meantime, I have lost, I have qualified BA, my lord. So I should have been put in the BA category. They have been placing me in the IA category, IACT category.
Did you inform them that?
Yes, that representations were there, my lord. Immediately upon.
What is that rule?
Annexure 2.
I want to see the rule, which says if you get value addition by like BA, etc., you should be given higher grade. Which is that rule?
So that gradation list will be prepared accordingly.
I want to. This gradation list will be prepared by some FDC.
Yes,
but I am not. But I have to see the law.
I will produce that seniority.
Call next week. That's the request.
What for the?
Which rule says if there is higher educational qualification, you should get higher gradation?
Well,
that I want. Because I have not yet come across such rule as it.
No, I will place that.
Okay. Next.
Item 25.
25. Yes.
In the petitioner challenging the illegal issuance of legal certificate, deleting the name of petitioner. Annexure 5 is here, presentation.
You have sought for cancellation of airship certificate. Airship certificate. Legal airship certificate.
Legal certificate.
That should be cancelled.
Yeah.
Hold inquiry and.
My lord, I am assisting. Person who has expired, 2 wife. The present petitioner is the son of the first wife.
So
while they are getting the legal heir certificate under the miscellaneous rules, so they have deducted the name of this present petitioner.
From that.
Exactly. They want there should be further inspection or investigation. By the process, their name may be included in its father's legal heir certificate. That is the sum and substance. Yeah,
okay. But it is appealable order.
This is the appealable order, in fact.
Sir, you filed an appeal. It is. I have held that it is an appealable order and revisable order also. Justice K.R. Mahampatra has held that this is a revisable order, Nugent Bench decision. I have held it is an appealable order. Therefore, you file appeal within 6 weeks. We'll give you time. The short grievance of the petitioner is reflected in the prayer column, which is not that happily worded. First off. Next. Learned AGA on request appearing for the OPs submits that the grievance of the petitioner can be worked out in appeal or revision as provided under rule.
Appeal is to OP number 3. Under rule.
Which is that rule?
Rule is rule 11. Miscellaneous certificate rules. That is rule. I can write down.
Under the provisions of Orissa miscellaneous rules.
Miscellaneous certificate rules.
Okay. First. Confronted with this objection, learned counsel for the petitioner in his wisdom submits that liberty be reserved to the petitioner to take recourse to appeal for revision remedy, keeping open all contentions of the parties. First, this is an innocuous submission. First, next one, in the above circumstances, petition is disposed of, giving liberty to the petitioner to invoke appeal for revision
to OP number 3.
To the jurisdictional OP or to under the provisions of the subject rules within a period of 8 weeks. First, if the appeal for revisions is accordingly filed, the same shall not be negative only on the ground of delay, lapses, or limitation. All contentions kept open. Next.
26. 26?
Yes.
Here, my lord, I am a transporter in the, my lord, fed opposite party number 1 and 2. Transporting the milk, and my lord, they have blacklisted my vehicle without serving me any show cause, my lord. That is why I have come before your lordship, my lord. Though they have come, my lord, it was done in the month of, I may fair, my lord, it is month of December, yes, it was done. Thereafter, I have given their explanation that I was not well, my lord. That is why I could not give them also repentation. I have given them the repentation in the month of only this August, my lord.
Vehicle is seized or vehicle is with you?
Vehicle is with me. They have
prepared for transportation of milk.
Yes, ma'am.
But any rules are there for that?
No, there is a contract, my lord.
No, that's not there. Contract with whom?
With the opposite partner 1, my lord.
That contract you want to enforce through the writ?
No, what has happened, my lord? This blacklisting is without any so-called notice.
Where is that blacklisting now?
That is order at, my lord, Annexure 3, my lord.
The 3?
Annexure 3 at page 18, my lord. No so-called notice not served directly, my lord.
But theft of milk and other things has happened now.
Yes, my lord. That has to be some, my lord, there, because where the loading point is there are CCTV installed, my lord. No inquiry was conducted, my lord. Nothing was done. I was never.
Like notice.
My lord, he is appearing for the.
I am instructed, my lord, to appear in this.
I'll submit a copy.
You accept notice? I accept it. Kindly do not use the word beg to appear. It is your very valuable right of the bar.
No,
You said I beg to appear.
No, I said I have instruction to appear. I'm sorry if I. I never said beg to appear.
Bar should be on its.
No, I never said that.
On its leg and tell the judge.
No.
Judge, this is the law. Do like this.
Unless I am authorized, my lord, I cannot appear in that.
I thought. Yes, issue notice. Shri Mishra.
Satya Sundar Kanongo.
Fine. So I made to learn so many things. Yes, including pronunciation. Accepts notice for the all of this.
All of you.
Enter all of this. First, we want to file objections.
Yes.
No. Objections to the counter to be filed within 2 weeks. Failing which, right to file one stands forfeited. And petition may be taken up. Petition amendments may be taken with face value. Yes. Call after 3 weeks.
Copy this out, my lord.
And sir,
You copy. You copy. You give two copies. Because one he has to retain, one he has to send to the client.
Yes.
Item 27? Yeah.
Please, Your Lordship.
Yes.
The petition is a graduate teacher will achieve level 4 graduate teacher. The challenge made Annex 5 the illegal memorandum of charges issued against him, Your Lordship. The date that I have given in the brief, Your Lordship, I invite Your Lordship on 14/1/20.
They ask you to file your defense.
But the basis of charges, Your Lordship, that is without setting the verification report from the concerned issuing authority, the charges, Your Lordship, against me that I have produced forged BAD certificate. But they have, I have setting for some documents, Your Lordship, as per Rule 15(3) of the SCCA rule, Your Lordship. They have to produce the documents. 30 days time given. I have asked for documents. They have without supplying the documents. Now telling me, Your Lordship, taking action, Your Lordship. And a similar issue, Your Lordship, was inserted.
When are you getting the documents? Tomorrow I am calling this. Give him set of documents.
No, it's a memorandum charges which is the impugned order dated 29/7/2025.
Yeah.
Correct.
My clear, my lord, page 18. But the documents which has been called for, it is at 11/8/2025 at page 25.
11/8/25. Page 25.
Now we are on 19.
On 29/7,
If
yes.
you do not give the copies,
No.
Kashinath, take out that judgment. Kashinath Dixit versus so and so.
The similar matter, Lordship, was pleased to issue notice and protect the petitioner.
It's not that simple.
Yeah.
Which are the documents you have sought for? When did you sought for? What is the relevance? These things. This is what Kashinath Dixit says.
Yes. On 29/7, they have issued the notice. On 11/8, we have sought for the documents.
Kashinath Dixita versus Union of India.
The 30 days time was there, which is completed on 29/8, the Lordship.
Have you seen judgment?
No, my Lord.
You don't want to see also when judge tells you?
Yes. Yes, Your Lordship.
I don't understand. How Saraswati will come to you unless you are very humble and this one, unless you keep all your sensory organs open. How Saraswati will bless you? Isn't that? Vidheyata is the first requirement of Goddess Saraswati. Then only she will come. No, it's not. At least when judge tells a decision, you should fail to say, I will look into, sir, I will come back. It is damage your case right now.
86 Supreme Court.
86 Supreme Court.
Kashinath Dixit versus Union of India.
Yes, Kashinath Dixit. Very easy to remember the name also.
Because of this court.
Yes. Just look into that judgment and come back. All right? Well, when the next sitting is inquiry sitting, it is fixed. They have asked you to file defense.
30 days time was there, Lordship. On 29/8, 30 days over. They
Call this matter next week.
holidays were there, Lordship. So today they may take action, Lordship.
What action will be taken?
They're terminating, Lordship. Others have been terminated. For that, in that case, Lordship.
Call tomorrow. Just look into which are the documents to be given to him. Bring one set of documents. Okay? Tomorrow, let us hand over the documents so that we'll give some time. They will file the defense statement. Okay.
My lord, this is from Poland.
So, about 4 days?
My lord, this is memorandum of charges.
Correct.
So after getting the documents,
But
I
you
have
have
to
sought
file my
defense
Suka's
statement.
reply.
Defense statement you have sought
Yes,
for.
ma'am.
To prepare defense statement, I need ABCD documents.
Exactly.
Yes.
In the meantime also, they have to sort for the instruction. Whether in the meantime, that is an 11/8, this is the representation.
Anyway, what I am suggesting is, now you take a call on the representation. Till you take a call, don't proceed.
Let me take instruction today. I am trying my best.
Can you call it like day after?
No, tomorrow. Ma'am.
Tomorrow? One day extra you take day after?
I will take telephone.
All right. Call day after tomorrow at the request.
Till then, Lordship.
Nothing like that. All the so fake certificates and other things is there. Yes.
This is day after.
Yeah.
Excellent.
Item 28. Look into that caution of the Dixit.
Yes. Okay.
May I please your lordships?
Yes, sir.
My lord, the petitioner is before your lordships.
Can you be a little nearer
Yes,
to
ma'am.
the mic?
Yes. The petitioner is before your lordships for unauthorized and illegal construction of additional classroom and improvement of other educational infrastructure of UP school, Goodbye UP school, in his own plot, private plot.
In your property?
Yes, my lord. Because yes, ma'am.
You file a suit.
My lord, it's a government project, my lord.
That's all right.
My lord.
How? Government will read a 68 Supreme Court.
My lord,
only the Constitution benches.
Without any measurement, without any.
We take all those grounds in the suit.
My lord,
All grounds which you are taking here. What Justice Krishna here said long ago.
84.
Reliefs that can be granted by the High Court can be granted by the Civil Court. But all reliefs that can be granted by the Civil Court cannot be granted by the High Court.
My lord, only demarcating by land, whether my land is a government land or a private land. I have annexed the.
How you
ROR.
became the owner of the land?
My lord, that there is ROR is I have filed.
You show me how you
11, page 11.
Page number
11, my lord.
Is it a sale deed?
No. This is a ROR.
ROR is not. They have only presumptive value. Very loose presumptive value. This is what Apex Court said in 1953 from Maharashtra case. We have followed. Every High Court has followed. Your High Court has also followed that judgment. So where is your sale deed?
Sell it, my lord. Grant me time. I will produce, my lord.
Counsel for the petitioner seeks time to furnish prima facie material to vouch his claim that he is the owner of subject property. First off, post this matter, after such material is filed along with the memo in the registry. Come on, and not otherwise. Okay.
Obliged.
Item 29.
29. The present petitioner is a developer. He proposed a plan to develop a residential cum commercial unit. This particular writ petition concerns the commercial unit, which is a mall, Melons. The mall has a basement which is dedicated for the parking.
They can't collect the parking facilitation charges.
That is what the development authorities, by virtue of a notification, has promulgated that we cannot charge parking fees, even though the common area and the basement belongs to the petitioner. So the contention of the petitioner, Melons, is of threefold. One is the development authority is only asserting the authority to look into the building violations, if any, or regulations.
Not in this respect.
Not in this respect. And Malats, the Honorable High Court of Delhi, Malats, recently has passed an order on the similar issue, on the similar line, that parking charges can be levied, Malats.
But there is a contra decision I read about 4 or 5 years ago of Delhi judgment, Justice Rajiv Endlaw.
That's your lordship. I'll take your lordships to the contention involved, para 1. Paragraph 1, Malats. May placement.
Nothing. I have read that.
What?
Para 2.
Para 2.
Let us issue notice. Let us see what they will say. All right, my lords. Issue emergent notice. Learned AG is requested to accept notice for
1.
Emergent notice to the rest. First off, one sentence you have heard Shri so and so. He places reliance on the Delhi High Court decision, the Delhi High Court judgment, not reported.
We could not find it in the SSC online.
Is it?
It's with the.
Okay. A neutral citation also it does not have. Yes, 2023 DHC 8343 DB. Just name it. First, issue emergent notice, let DGA requested notice of notice for one, emergent notice to the rest. Okay. Post immediately after service. Okay.
May I submit one thing?
Yes.
I have filed an interim application. There are twofold prayer. I'll confine it to one prayer, that not to take any coercive action against the petitioner. Pursuant to, because there's a...
Let them file objection. There is another judgment. After all, we do not know. These judgments are law specific, regional law specific. So what is the law? You have to show parity. That law is same. This law is same. Such a view is given. It requires data consideration. Wait.
May I submit one? The similar issue had came before before this Hon'Ble Court in 2019 in another writ petition. And this notification also pertains to 2019. If your lordship permits, I may just hand over the order.
Any interim relief is granted?
Yes, therefore.
Then I have to grant. First sentence, persisting to service, so. In support of his contention that, in respect of parking facilitation charges, OP number?
It's the OP number 2.
2 has no jurisdiction at all. And therefore, the coercive action needs to be restrained. First off, in support of that, now we can put that. Place presses into service, Delhi High Court decision, judgment, so and so. And also, a coordinate bench interim order dated 27/11/2019, entered in WPC 22184 of 2019. First. Next paragraph. A division bench of Karnataka High Court has observed in 1974, etc. I give that from my notes. That where an interim relief is granted to a litigant, other similarly placed litigants cannot be ordinarily denied of the same, the right to parity in treatment being the rule of adjudication. First, next paragraph. In view of the above, OP number, the OP number 2 is restrained from, taking any coercive action till pursuant to impugned order till next date of hearing. Yes, you argued very well. This matter is still pending. Call this matter along with WP number, whether it belongs to my roster.
Let's building regulations. Does
it belong to? Call this matter along with so and so. If that case also fits into the roster of this court, and not otherwise.
This case can be called for the reference also. For reference, it is required for the proper adjudication.
No, but that matter is still pending. What I say is, suppose I do not know whether it fits into my, is it yearly roster or subject-wise roster, overseas?
Year-wise.
Year-wise roster.
It is year-wise roster.
Therefore,
Item 30.
Your petitioner is a widow, my lord, of a deceased employee who, after putting 24 years of continuous service, died in harness and prays for regularization of his service of her late husband.
Who died on which date?
Died, my lord, 18/10/15, the husband of the petitioner.
18/10/2015.
After putting 24.
I'm asking a question. When he died?
18/10/2015.
18/10/2015.
I've given the death certificate also.
1 second. But he did not ask for that relief.
Yes, already asked for it. That is, that
had asked for.
Yes, that is also kindly see the Annexure 1 document, Annexure 8. Earlier 2013, the husband of the petitioner, along with 4 similarly placed employee, approached this court by filing WPC number 22592/2013.
take notice.
Now, my lord, so for the other four employee, you have also already decided the issue and they have already got the benefit.
They have got the benefit.
Yes, that I also.
Take notice, you give, let him see, look into the papers. You cannot make
What I pray, taking the recent development, I made a grievance for the authority annexed
that
11.
representation is considered
Because
sufficient.
the similar person already got the benefit recently, you will also been division bench passed the judgment that confirming the single bench judgment.
The short grievance of the petitioner widow is as to non-consideration of her representation or regularization of services of her deceased husband who breathed his last in harness on 18/10/2015. First off, learned counsel for the petitioner submits that this is the second round of litigation and that the deceased husband himself had filed the WP number, OA number,
WPC.
WPC
22592
of 2030, which came to be disposed of by order dated 18/4/2019 by a coordinate bench of this court.
Division bench, madam.
By the division bench of this court. First off, counsel draws attention of the court to the representation dated
Annex 11 dated my lord 7/4/2025.
7/4/2025 at Annexure 4.
11.
11. Annexure 11. Wherein the request is made to the jurisdictional OP to regularize the services of deceased spouse. And that
Taking Annex
no
10.
decision is yet taken on the said representation, although in respect of similarly circumstanced employees, a favorable decision is taken. As has been reflected in
Annex 10, the judgment,
where is that?
page 37, 10 series. The single bench judgment, you will also be in division bench.
Not that you said that the others were regularized.
Yes, pursuant to this order, Annex 10 judgment.
Regular. What you written? By a coordinate bench of this court in WPC 10517 of 2022
And upheld by you will also be in the writ appeal number
disposed of on
4/3/2024
and
confirmed with writ appeal.
And that the same has been confirmed by the division bench in writ appeal number
2793/2024.
Page 50, my lord, that is.
50. Writ appeal number 27.
Page 50.
2790. 2793 2024. Disposed upon 27/2025. Next, page 51 is the merit.
Writ appeal number 2793 of 2024. Disposed of on 2/7/2025. My opinion.
Yes, you will also be in division bench. Confirm the order.
First, counsel submit that. In terms of all this, if a direction is issued to consider the subject representation, his client will be satisfied. First off, next paragraph. Learned AGA, Mr. Mohanty, on request appearing for the respondents, although initially resisted the petition, now fairly agrees that the subject representation of the petitioner should meet its fate within a reasonable time at the hands of
OP number 1.
OP number 1.
First off, he seeks, he submits that all grounds should be resolved. First off, in this proposal, counsel for the petitioner is also agreed. Next paragraph, in the above circumstances, petition is disposed of, fixing a period of 8 weeks for consideration of the subject representation in the light of coordinate bench decision and division bench decision of this court within an outer limit of fixing the period of 8 weeks for disposal of so and so, and also to inform result of such consideration to the petitioner in writing. In the first all contentions kept open to solicit any information, document, from the petitioner as are required for due consideration of the subject representation. Now no cause. Next.
Item 31.
Yes, sir.
But till now, no counter has been filed. One is matter is 2015 and one is 2019. Here, my lord, the background is necessary. What has happened, my lord, here? One Durjodhan, my lord, Rath, he had some property. Which
Yes,
was,
who appears for the respondent?
Development authority.
But who is the answering respondent?
he,
The order is by municipal.
they were the first, they passed the order, thereafter it was been transferred to Bhubaneswar municipality. Notice has been issued since 2019. They have appeared, but till now,
They have not appeared. Their advocate is not there.
I have again served them a copy.
No, I'm asking a question.
My lord.
Why can't you? Why can't you understand the simple English
I am
question?
not here, my lord.
You can say that.
Yes.
But if you assume something and answering,
Sorry, my lord.
then no meaning. I'm asking you whether the concerned body is represented by any advocate.
Yes, my lord.
Who is?
Janaranjan Mahapatra.
Make call to that advocate. We'll pass over this time. Okay. Give his phone number. We only will call. 2015 matter.
No.
2019
is my con. Municipal corporation. Municipal corporation.
I will not give time in this matter. I will pass over. You have to argue. Both sides have to argue. 2015 matter. People will laugh. People will stone my car.
P.K. Panda has appeared. One Mr. P.K. Panda has appeared.
P.K. Ponda.
Yes.
Yes, make a call to Mr. Ponda and ask him to come here.
First matter and second matter.
Second matter is order. First matter.
Yes, pass over. Get ready. Pass over. I will not give time. If we are keeping these matters like this, people may pelt the stones because I have very often to travel to my place and come back. I will be at risk. I can't take that risk. Yes. Pass over.
Item 32.
Send for Mr. Panda.
When is your lordship, my lord?
Yes, sir.
This is being the cover of the Supreme Court as well as your lordship's divisions and matter, my lord. Please make a glance.
No, first, what is the subject?
This is a case regarding the appointment of a rehearsal assistance scheme. Petition.
Appointment in rehabilitation. That is compassionate appointment.
Yes, my lord.
Then give the facts.
But the fact is that petitioner's father, who was working as a piano, left his motor coil on 5th July 2021, my lord.
Yes, 721.
My lord, I annex of it. That is the death certificate, my lord.
When did you apply for?
My lord, he applied. I had annex one that was rejected because
applied on.
That is a rejection order. Please make a glance. Annex one the rejection order. Please make a glance.
That was 4823.
My lord.
Now, when did you file this petition?
On 23, I filed the petition, my lord, before lordship, my lord.
23.
My lord. And it is purely covered up with Supreme Court as well as your lordship division as a matter. Please make a glance.
Yes, pass on. I give copy to your friend also and send to me.
Your lordship division order is there also.
Saying? What does it say? I don't remember. I have passed many.
So, the Debasis Panda case is concerned, your lordship, while sitting in the division, will pass similar.
If the case is considered, well, you will be happy with that.
Within 3 months. That
even all these years they have not considered. No, I will not pass consideration order. I have to argue the matter on merits. Consideration will not help.
But Supreme Court is there. Please make it a Supreme
I am making in your favor some statement. Why can't you understand? Well, we don't want to understand. Simple English, let alone law.
Matter is lying since 2023.
That is what I am telling you. If I make an order, consider. They will take that order and put it into dustbin.
But no confidence.
This order is complied with properly by the state. No confidence. What in other high courts they do it? You have to show some confidence.
I pray only as per the Supreme Court decision, your lawsuit matter may be disposed of. There are 2 decisions, covered or matter. That's
they only say consider. Will you be happy with that?
I hope that will your lordship order will be carried out immediately.
I was not that hopeful, but I appreciate your hope.
Your lordships are ultimately only carried out without any hesitation.
But we have file counter, my lord.
You have file counter?
Yes, ma'am.
No argues.
And my lord, let's see.
So he died on 5/7/21.
My lord.
And 4/8/2023, the same is rejected.
Yes,
Right? Application for compassionate appointment is rejected.
my
On
lord.
what ground?
On the ground, my lord. As per the 2020 rule, my lord, rules, sub-rule 6, my lord, rule 6, sub-rule 2B of Rehabilitation Assistance Scheme Amendment Rule 2022, my lord.
No, 22. How can you apply 22?
No, 20, my lord. 20. Sorry, 20, my lord.
Where is that your order?
That order, the annexure 1, page 11.
Annexure 4.
1, my lord. Page 11.
Page 11. You tell our registry not to put the seal on the dates. How I should make out? There should be some space where seal should be put, not any place wherever they want.
Page 11, my lord.
What are the grounds on which you have?
The sole ground is, my lord.
19 points.
My lord, she secured 19 points. And as per rule 6(2)(b) of the said rule, my lord, he is not eligible, my lord. You have to secure more than 44 points, my lord.
More than 44 points.
My lord. Sub-rule D of rule 6, my lord, 2C, 2D. If the total points allotted, I am placing, my lord. If the total points allotted to the applicant in part 1 of the evaluation sheet is between 44 and 60.
Brother,
my lord,
you have received 15,25,650 and still you want their appointment.
My lord, my family is facing in a distress and a disable condition.
What did you do with this money?
And my condition before you.
I am asking you, what did you do with this money? 15 lakh. It is for distressed people. See that benefit of DCRG and leave salary, 15,25,650 is paid.
That is the length of service 26 years. And the benefit of DCRG
and leave salary. 15,25,650 is paid to you. Still you want compassionate appointment.
This is the salary of my father, my lord.
That is the DCRG comes after retirement. It's a terminal benefit. You should read good books on service law, like Kulashrestha, Justice Rama Joyce, and Samaraditya Pal. Otherwise, you start making this argument. I have to spend time on that. This is the highest court of the state,
my lord,
where performers are to be entertained.
Well, my submission only one line, my lord.
One line submission is not going to help you. I will hear 10 lines, provided it has any merit.
Pecuniary condition must be considered, my lord.
Your pecuniary condition is you are holding 15 lakh rupees purse in your hand.
No, that is salary of my father, my lord.
That's but after whom it has come to your hands.
When my father died in harness, my lord, the distressed family should be also protected by giving job.
Where is the distress?
This very much distress, man. Nobody has got appointment till today.
No, that is not the question. That is not the question. Question is compassionate appointment. What the apex court has been saying throughout is to those who are in distress because of untimely death of the breadwinner. Now you have got a bread here. No, not a bread, you have got the bakery itself. 15 lakh rupees you have got and still you want a compassionate appointment.
Before your lordship, my lord, only my
petition is rejected on the following grounds.
My lord, I am permitted to file the Supreme Court petition. May kindly be quoted, my lord.
Yeah, I am quoting that. Why do you think that I will not quote?
Sorry, my lord, I am extremely sorry. I have given the Supreme Court petition. I am quoting that may be disposed of, my lord.
Yes, yes. But petition is dismissed on the following grounds. Number one, it has been the consistent view of the apex court that the provision for compassionate appointment is not to catch the windfall, but to overcome the distress because of the untimely death of the breadwinner of the family. First stop. Learned counsel for the IGA appearing for OAC, appearing for the respondents is more than justified in drawing the attention of the court that the family has received the benefit of DCRG and the relief salary of 15,25,650, which aspect has been taken into account, and only thereafter the points have been accumulated in terms of Rule 62B of RAS Amendment Rule 2020. Wait. First, next paragraph. Learned counsel for the petitioner places into service the apex court decision in state of Odisha versus Chitaluha to contend that in terms of the ratio decided therein, his client is entitled to compensation. First up. Which paragraph supports your case? Well,
My lord, that is the para page 36. Para BI. Please make a glance. I may permit to read also. Page 36. BIA, the directions as issued herein above shall apply mitius mutandi in all pending cases. The aspirants are not required to take recourse until their claim is rejected. Pending writ petition before High Court, if any, shall also be disposed of in accordance with the law, the direction issued above.
How it comes to your help? How it comes to your help? The decision is taken already.
My lord, with only it is a direction, my lord. It is observed with direction to this all high courts, including Tergam. That's why I pray, my lord, that maybe.
How, brother? How is it possible?
With that observation, matter may kindly dispose of, my lord. I humbly
when asked as to how the apex court decision in so and so would come to rescue, aid of the petitioner, his counsel submits that para Roman,
my lord,
7,
Roman VI,
Roman 6,
VII,
7, Roman VII,
my lord,
comes to his aid. First, the said paragraph reads as under. First, the submission of the counsel is illogical, to say the least. Dismissed.
Another division bench order is also
yes,
there.
we will see that when the apex court order.
Item 33.
Yeah.
Hello, here,
Yeah.
the petitioner, while working as an assistant teacher in a primary school, my lord, a disciplinary proceeding was initiated against him.
Yeah.
And he was dismissed from service. Your lordship may kindly come to Annexure 12, page 44, my lord.
Annexure 12. You have challenged Annexure 16 actually.
My lord.
Let us
Annexure 16 and appellate order is confirming the order passed by the disciplinary authority, Annexure 18. Both the annexure I have. Yes, I am coming to Annexure 16, my lord. Whereas a disciplinary proceeding under rule so and so by memorandum number so and so charge has been framed against such and such while discharging duty as assistant teacher at government so and so school, various charges for submission of fake B.Ed qualification. See, Ponda has submitted his written statement so and so, whereas an inquiry has been ordered by the order number so and so, an inquiry to the various charges framed against such and such. The government school has been appointed as an inquiry officer. Whereas the inquiry officer,
they say you have committed fraud and forgery,
my lord,
and you have taken money.
My lord,
No,
my lord, my case is I have not taken any benefit by this certificate, my lord. This fraud certificate which was dictated and I was inside the custody for 45 days. Then after this honorable court released on bail, thereafter I was again reinstated into service.
Thereafter, proceeding was done up and I was removed from service on the allegation. Yes, your Lordship may kindly come to page 44.
Yeah.
The allegation, page 44, annexure 12. Whereas a disciplinary proceeding under rule such and such has been, yes. What are the charges?
One second. Slowly, you have to take the judge also together. Yes. So rule 15 CCA rules constituted gross misconduct, lack of integrity, breach of trust. It must be, not breach of trust. So this is the proposal notice.
My
Hold inquiry.
My Lord, only my argument will be before your Lordship, very short argument. Only, yes, it was found, it was fraud, but I have not utilized it.
It is like
and
saying-
I have not taken any.
1 second.
My Lord, I have not taken any benefit out of those.
I am answering. I am answering your question.
My Lord.
It is like saying, I have only counterfeited the coins, but I have not put them into circulation. I have only printed the notes. Not means one single note is put into market. That itself is sufficient.
Even if when it was dictated, my Lord, I have applied to my immediate authority, that block education officer, who is my immediate boss. I applied, you correct my front page of my service book because I have got qualification and I was duly selected by the government. That is no, my Lord, there is no counter to that. They will say yes. Because my selection and I am posting the assistant teacher post, that is all right. My qualification is I have city qualification. According to my qualification, gradation list was prepared in 2023. Everything is all right. But my Lord, it was subsequently found that I have produced some course certificate, by which immediately I have, on the next day, I have applied to the BEO. Time and again I have gone, sir, you please make it correction.
What correction?
I don't want to take any benefit out of those certificates.
That is like saying I print only,
my Lord,
but I will not put them in circulation.
Then, my Lord, your Lordship may allow me some time because I am not. My Lord, why I so? I have ground.
No time will be. First, it should be first time you should tell us, not after arguing the matter, knowing the code.
My Lord, what is the problem?
There is nothing in the code.
My problem is, my Lord, some extra problem I will tell you, your Lordship, my Lord. Because I have not filed this case. This is a transport brief. My friend, my Lord, my friend Bimbisar Das was conducting. He died, my Lord.
But you started.
And before that, my Lord, very unfortunate case. First, Vidyadhar Pradhan was conducting. He died. Then this case came to be Bimbisar Das, and Bimbisar Das died. Then I have got, this case has come to me. Perhaps 2 lawyers they were conducting. Within 1 year they died. First, Vidyadhar Pradhan, he was our bar secretary, my Lord. He died. I am also of that. For that reason, I want next week, let it come.
Call next week.
Yes.
But you can't retire saying on that ground.
No. I will further prepare myself, my Lord.
But I wish you should be Shatayushi.
My Lord, such thing happens. My Lord, why? Because
I am wishing you that you should become Shatayushi.
Yes, sir. Yes, sir. That is
object that.
No.
Therefore.
My Lord, similarly, I remember one thing when Dr. Sarangi, who retired as Chief Justice, my Lord, in his course, now my learned senior, Mr. Misra is the president. The former president, Mr. Vijay Das, was praying for an adjournment. Dr. Sarangi, division bench. Dr. Sarangi said, why? No adjournment. Now, my Lord, your Lordship may allow me 1 minute. No, yes, I am allowing you 1 minute. No, my Lord, yes, my Lord. First, this man had gone to Ashwini Mishra, senior advocate. He died in Corona. Thereafter, he went to Basant Naik. He died in Corona. Then he went to Sushant Pradhan. He died in Corona. Then he went to Ganeshwarath, senior advocate. He died in Corona. And when he has come to my door,
he is carrying the death warrant.
When he has come to our former president's door, somebody told he has gone to medical. He had gone for his checkup, my Lord. His oxygen is all right or not. Then he came back and got the brief.
After all, Palkiwala writes in his We the People, quoting Macomb Magridge, he writes, we are all under the sentence of death.
Yes.
Only its execution is stayed for an indefinite period of time. Because we do not know when we shall breathe the last, the Bimbisar, other side, other
Yes,
side.
yes.
Such a good person who can think very closely. When we close our eyes, we don't know. At least that should.
And you has feet. Bimbisar, that's why let feet hurt. All in a sudden.
All right. So week after next, we'll have this.
My lord.
Very week after next. Get the request of it. Yes.
234. Lord, I am for the petitioner and I have got no objection to the amendment suggested.
What is that amendment that you want?
Only change of name of the council mentioned in the order.
Registry to print the name of Sri so and so.
Shashwat Das. Instead of you, Beura, it should have.
Now you are here, you have already got the Khaznishtana.
Well, 34 and 35 are same. Same day, your lordship passed the same order.
34 modification. Just modify in terms of application, supported by amendment. Rectification as sought for is granted. Registry to rectify and issue a free copy if applied for.
Yes.
Item 36.
Item 36, may I please, Your Lordship?
Yes.
On previous occasion, Your Lordship issued notice to the opposite party number 6. But the noting says that the writ application number has been wrongly typed in the order statement.
Is it? Which is the right number, brother?
Right number is 22286, my lord.
22586?
586 has been 86. 586 has been wrongly typed.
Number to be rectified as 22286.
My lord,
in the place of 22586 of 20.
My lord, further time may be granted to file notice. My lord, I have already filed the requisites, but notice can't be issued because of the wrong.
Okay. The requisites to be processed in the light of rectification. Okay.
Item 37.
37, I may be pardoned, Your Lordship.
37.
37, I have filed a memo to withdraw this case, Your Lordship.
Counsel for the petition. Why are you not happy with the court? Why you want to withdraw?
Oh, Your Lordship, the other similarly situated persons have been given relief by the BDA itself.
Yeah.
Because of the pending litigation, my file is not being processed.
Learned counsel for the petitioner seeks leave of the court to withdraw the petition because you have to ask sometimes. You will say this court is never going to. One matter it happened in Karnataka, I tell you. Where memo, generally, whenever memo was moved, we used to say we used to feel very happy. Then one case has at least gone now. It's not, it should not be like that. That's another.
No, so that is not the case.
In terms of memo, it is petition is disposed of. Thereafter, the concerned judge went back to the chamber and saw the memo. I have lost all faith in the Indian judiciary, and therefore I don't want to press this petition here. And judge had agreed with that. Therefore, he allowed the petition to be. Therefore, generally, I ask why they want to withdraw the petition. We should not rejoice if a petition is withdrawn. We should feel bad if it is being withdrawn. Yeah. Counsel for the petitioner seeks leave of the court to withdraw the petition. First off, right to withdraw being part of right to institute litigation, the leave is accorded and petition is disposed of as having been withdrawn.
Published.
Item 38.
May it please, Your Lordship?
Yeah.
My Lord. This is a matter, Your Lordship. In the first matter, I am for the petitioner, Sarath Kumar Samal.
There are two matters now.
Two matters, Your Lordship.
What is that your challenge here?
My Lord, I am praying.
I have for PDA. I have not filed counter, but to my knowledge, one case is there that the Honorable Division Bench already taken a decision. So far as commercial plot is concerned, it will put into auction because it was to augment has the most valuable piece of land. I will get that judgment if it can be taken out day after tomorrow, so that I will get out.
Call day after tomorrow. At the request of the senior advocate appearing for answering OP.
Item 39.
Yes, sir.
I am for opposite parties.
Call this matter of 2 weeks to enable counsel for the petitioner to come and argue Next.
Item 40.
Tell that, just phone him on the council and tell him that we have made this out, okay? Sir.
Item 40, if I may please your lordship.
Yes, sir.
Present writ petition has been filed, being aggrieved by, counter is there. Being aggrieved by the order communicated, which is by the Annexure 6, my lord.
Transfer of the plot.
Yes, my lord.
You want permission for transfer?
Yes, my lord.
Now they are saying they don't want to give the permission.
Yes, my lord, because
No, I am asking, I want to know.
Yes, my lord.
Just I want to know. You can halt, then you can answer after I understand.
So the gist facts is that, my lord, my vendor was the original allottee. Right?
When was he allotted?
He was allotted in the year on 24 February 2007, my lord.
You bought, this is original allotment.
This is original allotment.
And you bought it on?
I bought it in the year 2009, my lord, wherein
your sale deed has only year and but date also.
The lease date as of it has not been granted by the CDA.
Anyway,
but the letter of,
means it may be January 1st to December 31st. I just want to know the date.
The date is 3rd of August 2009, my lord. Wherein
3/8/2009.
Wherein the CDA permitted the transfer, my lord.
At that time.
At that time.
Transfer of lease slowly.
Yes, ma'am.
You have to hold back.
Yes, ma'am.
You are holding back.
I humbly apologize.
Otherwise, how I see you are saying something which judge has to process. Once you say transfer, so many things come before my eyes, including summons jurisprudence, Section 5 of transfer of property. Several provisions, very fast I scan them, in which it may fit into. Whether limited transfer, unlimited transfer, 5 modes of traditional transfer. These things. Therefore, I tell people, when you make one statement, you don't give a pause. Pause is very important part of speech. Acharya Rajanish Osho says, pause is an integral part of best speech. Therefore, you should resist your temptation to argue. You should ensure judge understands the case. If I understand, you will get the order. Otherwise, I may commit mistake. What's the point?
Yes,
from that angle, don't mistake me for saying all this. There is one best book, Art of Argument. Another, How to Win Every Case. There are 2 books by Gerald, the Mufisi lawyer from America. Best books, how communication skills. All right, just look into it.
Yes, ma'am.
I will ask you some questions on those books. You can't just say yes, next time I'll ask some questions on that book.
Sure.
All right, now start. Your allottee, original allotment is 24 February 2007. Your client bought it on 3/8/2009. It was a lease.
Yes, madam.
And it was not full ownership.
Yes, madam.
And lease, as the CDP then stood, was permissible to be transferred.
Yes, madam.
That is the case.
That is the case.
Then what happened?
While the lease was transferred, I deposited all the statutory dues that was asked by the CDA to the petitioner. Subsequently, I preferred in the year 2012, I applied for a permission.
You should tell the date. I'm very particular about date.
Yes, madam. 24th January 2012, madam. I entered into an agreement with the opposite party number 4 to transfer the land in his name.
24/1/2012. 2012.
Yes, madam.
This is agreement to sell.
Agreement to sell.
Agreement to sell the lease. Leasehold.
To transfer the lease.
That's what.
Yes, madam.
Yeah.
Subsequently, my lord, the transfer application I filed on 8th of February 2012.
Transfer application.
Yes, my lord.
Where is that application copy?
That is at Annexure 4, my lord.
Transfer application is dated?
It is 8th of February 2012.
Let us go to transfer application.
Yes, my lord. It is at page 25, Annexure 4.
It's in the format.
Yes, my lord. It is in a format.
Format is prescribed under anything.
By the CD authorities, man.
Your rules are there prescribed in the format.
This is approved by the authority.
The transfer is approved.
The format is
approved. So there is a prescribed format.
Prescribed,
though not by rule.
Not by.
Do you doubt his version that this application was given for transfer?
Yes, it is given.
It's true. Okay. Then what happened, brother?
Then, my lord, the concerned parties were issued notice to appear personally before the concerned authority and produce all the documents. That notice was dated 23 March 2012.
And you went there.
And the parties appeared on 26th March 2012.
Then what happened?
Then the application was kept pending without taking any decision, because of which the present petitioner was again compelled to approach this Hon'Ble Court earlier in a writ petition in 2019, my lord. It is WPC number 13055 of 2019. My lord?
Disposed of on?
Disposed of on 5th of August 2019.
Saying consider.
Yes, my lord.
Then what happens?
Then, my lord, subsequently in 2019, notice was issued. That is at Annexure 6, my lord.
You are not mentioning the date.
Yeah, the
you
date is...
can vote before the bar council that never I will tell the date to any judge.
No
problem.
I humbly apologize.
Yeah.
It was on 2nd of December 2019.
2019.
What happened? Therein, it is stated that your request for third-party transfer of the aforesaid plot
is rejected.
Cannot be considered as the plot is included in the list of Special Finance Audit Report of Finance Department Business.
Means what?
It basically means that the case of the CDA right now is that the land was originally allotted to my vendor was a double allotment. Even though subsequently they have permitted the transfer in my favor. Right now they say that upon investigation it is found.
The matter I have decided, which is that matter? You only have argued that matter.
Yes, ma'am. Susama Misra.
Yes. Covered by judgment it is.
To that effect also.
Their manners dealt with about that prepossession transfer and all this.
WP number?
Susama Misra. The name is, I remember that name, Susama Misra. It's not common reporting, but I got that. Susama Misra versus State of Orissa. It is concerning BDM.
Any other defense other than
the thing is that very simple manners, the same thing, 3 points. That task force, because of multiple allotments, the cabinet constituted a task force. Task force submitted a report that is commonly known as Taradat Committee report. This report deprecated that prepossession transfer. They said that you take action immediately to recover that properties matters from them because it is illegal transfer. And subsequently, what happened? Thereafter, also the task force report also given another suggestion that this list prepared is not exhaustive one. So a special audit should be conducted to find out any other cases are there or not.
This case is covered under the special audit report that yes, this the vendor got 2 plots, availed 2 plots, and sold this plot, also the other plot, sold both the plots.
Which was the first plot was allotted to him when?
Giving an affidavit. That's given there.
That affidavit you mentioned the corporation. When corporation was not in existence.
That is there, my lords. But here in this case, there is no such contingency like this. Here in this case, they are to disclose. This is the only distinguished feature. There, my lords, taken note of that. Yes, we have stated about corporation. The corporation was not in existence. And that my humble contention was that it was part of the municipality. But subsequently, that is a different concept altogether. Here in this case, they filed an affidavit that I don't possess any plot. But that is that affidavit by annexure B/2, page 11.
Where is which rule requires that person who seeks allotment should not possess more than 1 plot?
Well, that brochure itself. Brochure itself, application form, they have to give an undertaking.
Give and that. I do not remember. Just show that.
So that affidavit portion enclosed by the petitioner matters, so given by the petitioner enclosed to the affidavit application, I've given that. That is page 11. 11 of my counterpart.
It is not by the petitioner.
Into the plot number 2. Earlier?
Your paragraph?
Paragraph minus annexure B/2.
Annexure B2.
Annexure B/2. Minus 11. Page, minus running page 11. Minus internal page 11.
This is dated?
It's dated 13/12/1999.
What he has said?
He said, my lords, I or any of my family member, spouse, or minor children, as noted in the statement above, do not own or possess any residential house, plot, flat, building within the area of Cuttack Municipal Corporation.
Whether as on that date municipal corporation was established?
No, municipal corporation was not established.
Then what is the difference between this case and that case?
So that only thing is that here in this case, municipal corporation, let us consider it a municipality. Then also he was having 2 plots within that area, municipality, within municipality.
No, municipality is one legal concept. Municipal corporation is another.
Municipal corporation, that 2 laws there.
You are very specific.
But 2 laws that are so far that corporation is concerned, there are 2 laws. But earlier, what I got, subsequently I got that information. Of course, by the time I argued, that information was not possessed with me. Since much before that, the government made a notification declaring this Cuttack municipality and municipality corporation. I have to go through that. I have not gone through this, but I have to go through that. But here in this case, what happened?
When Cuttack Municipal Corporation was formed?
That information that the corporation, municipal corporation, after getting that that notification only, I can go through that. Yesterday, I got that information. Because that was 5th Session Divas, then I got an opportunity to go through that. That day, there is a notification like this. If my lords will be pleased to take up it, my lords, any day next week, I will get that.
In the meanwhile, you also look into that judgment.
Yes, my lord.
Judgment, I will give them.
Yes,
I will give them.
Maintain one set of all our judgments so that they become easy for me.
I will give that during launch. I will give that reference. That judgment minus that is in WPC number 8344/2022. Disposed upon 13/8/2025.
No, I feel I vaguely remember because I am the author of this judgment.
Yes, my lord.
Where I have said at that what date the municipality came to be.
No, probably my lords have said that it was only it was in
only
it was in the village that Gram Panchayat.
Correct.
Then also, of course, but with due humility, I was not aware of that notification. I couldn't bring it. It's my fault, I couldn't bring it.
No problem. No problem. Right. Next week, we will look at the request form. Great. So push this matter. Next, yeah, another 10 minutes because I was late today. Wait. Yes. All right. Yes. Now. Yes. 41.
May I please your lordship?
Yes.
Lord, here the impugned order, your lordship should see.
Others may go for lunch so that after this matter, I will also go there. I'm sitting extra 10 minutes extra than usual because I came to court a little late. That's the reason. Yes, I have to compensate that within 2-3 days. Yeah.
Your lordship should be the annexure 12 and 14.
Can you make Brandy's statement? 3 lines. What is the case?
I'll manage. What happened?
Brandy. Justice Louis Brandy was the famous judge of US Supreme Court. He was a great lawyer. He used to coin 3 sentences to make submission to the court.
Right, man.
That was the end of his argument. That way I'm asking. I am likening you to Brandy's. Not that way. Yes.
So what happened, my lord? There's a trust which entered into an agreement with RRIT, which is Rourkela Regional Improvement Trust, for allotment of land, which was supposed to be handed over by the state government to the authority or the RRIT, that improvement trust.
It's a statutory.
It was earlier. Then it became RDA subsequently.
RDA means Regional Development.
Regional Rourkela Development Authority, like the CD or the VDA. So
this is under that 1982 Act.
Yes.
82 Act.
No, ODR.
Orissa Development Authority.
1982 Act.
So what happened, my lord? Initially, there was a particular amount which was fixed, or from me to be paid first at the time of entering into the agreement with them, and subsequently when the transfer is to be executed.
You are an unauthorized occupant.
No. I am a trust which is for the purpose of running a college. So this is the name is Kanak Manjari, Lord, the Institute of Pharmaceutical Sciences. So what happened, Lord? And subsequently, when 89 the agreement was signed, subsequently in 90, they said that the land has not yet been transferred by the government to them. So the lease deed cannot be executed. But in the meantime, I had started construction. They gave me the permission to construct, and I started functioning. The college started functioning. Then subsequently,
without transfer by the government.
Without the transfer. That is on record, my lord. Even till date also, it has not been transferred. So what happened then? They raised subsequently in 2005. They said, no, now you have to pay an enhanced amount of 18 lakhs odd. Instead of 5 lakhs, you have to pay 18 lakhs, 84,000 or something the amount was there. So I went to the initially consumer forum. So consumer forum said, since the initial deposit you had made 1.5 lakhs and you deposit another 1.5 lakhs, no coercive action will be taken. Then, my lord, at that stage, I deposited that amount, no coercive action was taken, then I withdrew that application.
What application? That
before the consumer. Yes, complaint itself. Then they raised a demand, they enhanced the demand to 7 crore 84 lakhs subsequently. So when this 18 lakhs was there, I approached when they gave me issued a notice for eviction. I came before this honorable court. This honorable court granted me interim protection subject to payment of certain amount out of that initial 5 lakhs. So later on in 2021, I said that, all right, whatever may be the situation, I'm ready now to pay that amount entire instead of pursuing the litigation, that 18 lakhs odd which has been demanded.
So I made a prayer before the court that I'm ready. Court said, okay, then if it is up to you that if you want to pay that amount, we can't stop, so you can. So I withdrew the writ petition. And I immediately on the same day, I made a demand draft. Though the withdrawal was unconditional, on record, there was nothing recorded because that demand.
1 second. In that petition, that 18 crore something.
18 lakhs.
18 lakhs.
Subsequently.
That was not when the petition was withdrawn.
No, not when the petition was. So
How long the petition was pending?
Lord, that earlier writ petition was filed. I'll just, my lord, read, from 2007 till 2021.
Just 16 years.
No, 14 years.
14 years. No. You are right. 2021 it was. You deposited that 18 lakhs when?
Immediately on the day I withdrew this writ petition, on the same day I made a demand draft and deposited with them. That is acknowledged.
So for 14 years that money was with you.
That money was with you. Yes. But when I deposited that, they didn't accept it. So they said, since it's an unconditional withdrawal, we can't accept. Then they calculated on the as on date the valuation, which came to my lords at annexure 12, if your lords.
Some crores. Some crores it will be.
7 crores, 48 lakhs odd. Which included, my lord, the land cost, then rent plus cess, and penalty for the defaulted period. So on that basis, then against that, I gave a representation to them. That this was the situation when I went to the High Court. And High Court protected me in 2007, not to initiate any coercive action. Then in 2021, irrespective of whatever the reason, I felt that instead of pursuing the litigation, since the institute is running, so I better deposit it and get it transferred in my name. So on that amount, if at all anything should have been calculated on that demanded.
To others who are similarly circumstanced like you, what they have done?
No, my lord, there was nobody as such. My lord, we didn't have any instances. Comparable instances was there. So this demand, what they made.
So you are aggrieved by that demand?
That demand. So I'll just take your lordships to the certain documents. What are the features of those documents? Your lordships may come to annexure 2 page.
Which is the first document pursuant to which you gained entry to the land which did not.
Exactly, my lord. Annexure 2, page 22. Your lordships may come.
How they described in that? They describe themselves as the owner.
The body, a corporate having so and so.
May I clarify 1 minute, my lord? The land situation, what are the previous land? Usually the government of Orissa used to transfer a patch of land to the development authority before making any document transmission, but it has been earmarked for development by the development authority. A particular piece of land has been transferred to development authority without any documentation. Then the development authority used to develop the land and allot it in the different plots and allot it to different persons, either by lease cum sale or outright sale or only lease or license for shoppings. They'll do it. And after that, they realize money from them for such allotments. From out of that money, they used to pay to the state government. Thereafter, state government executed lease deed. Here, lease deed has been executed in 2005. But before that, possession has been given to development authority. Development authority has also given possession to the allotee. Allotee used to make the payment to me. I want to make the payment back to the government so that lease deed can be executed. Now this lease deed has been executed. Full payment money I have not received from the petitioner.
What was the full?
Now my friend can continue.
What was the full payment?
Pardon, madam?
Lease was when the lease was entered into?
2005.
2005.
By government of Orissa and development authority.
Till then there was no lease at all.
No.
Which is the first, sir? Which is the first document?
Yes, that is the agreement. If your lordships would see page 22.
That's what. This is the 24th day of October.
1989.
1989.
1980.
Your Lordship, I look
Your
at-
Lordship, I come to the last paragraph of that first page of the agreement. Page 222.
Whereas
Whereas the governor of Orissa in favor of the first party has demised to the first party for the purpose of selling and leasing out sites for institutional purpose, the lands more fully described in Schedule A hereto, and thus the first party and the second party hereby acknowledge that he or she has understood the contents thereof. Then your Lordship may come to the second page, third paragraph. Then, my lords, the first paragraph, whereas the first party has been authorized by governor of Orissa to transfer the lease out and sell the site. And whereas the second party has applied so-and-so, and whereas the second party has deposited a sum of 1,50,000 rupees only to the first party towards sale price of the site and receipt of which the first party has acknowledged. Then, my lord, the conditions. The first one is that the execution of this document, the second party shall be put in possession of the site more fully described in so-and-so and continue to remain in possession subject to compliance of all terms and conditions of this agreement. Next, my lords, the second party shall pay balance consideration of 3,50,000 only to the first party on the date stipulated by the first party.
did you pay?
That you pay.
Did you pay?
They never raised a demand.
No, it is said there. Where
No,
is the
but
mention
the
of
dates have not been fixed. The dates which are to be paid, stipulated by first party as they say, those dates have not been fixed in this agreement. If your lordship should see, the second party shall pay penal interest on the defaulted installments at such rates determined by the first party. If I don't,
have you taken up that contention? Anyway,
Yes.
your petition.
I'll just, my lords.
Take illustration 1 to section 115 of the Evidence Act. Give Evidence Act. Illustration 1 to section 115 of Evidence Act.
I'm sorry, my lord, I'll just take up that.
Give our Evidence Act. We have taken it from Phipson's Evidence Act, English Evidence Act. Where it says like this is what my professor of evidence law used to teach us in the law school, where A presents to B that he is the owner of X land when he was not, and he enters into an agreement. Subsequently, A becomes owner of the land. Then he cannot take up the contention that as on the date I gave the land, I was not the owner. On that ground, he cannot register suit. That's how we don't have evidence.
Estoppel will come, my lord, there.
Estoppel is illustrated so beautifully. My professor I.G. Ray Gowder, one of the famous senior advocates at Harvard, used to teach us.
Lord,
take this. Just read
illustration
1.
A intentionally and falsely leads B.
Then read. Then just read. It
to
is
believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterward becomes the property of A, and A seeks to set aside the sale on the ground that at the time of sale he had no title.
Now read section 115.
Yes. When one person by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representatives shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing.
Illustration uses the word fraud, but section does not. An illustration has to be understood in the light of that section. It cannot widen the scope, nor it can squeeze the scope of the main principle. Rupert Crossan, evidence law. So beautifully he has written. Many books on evidence are really thrilling. I have read the best on evidence. one of the best books, best on evidence. Rupert Cross, the author of Precedent in English Law, he has written Law of Evidence, all foundational principles. Their illustration uses the word fraudulent. The argument was, no fraud is committed. Therefore, illustration is not invocable. The Bombay High Court rejected the contention. What illustration requires is not the requirement of law. Therefore, since you raised that issue, I am answering that question to you. Of course, thereafter much law has developed. It's another thing. I'm telling, since last about 10, 12 years, I have not read Evidence Act at all. Therefore, my knowledge of evidence law is not up to date. Although few rulings I can, this one. Anyway, we'll come back after eating the lunch. In the meanwhile, just look into that commentary of based on evidence on that principle.
All right.
Yes.
Yes. I may be pardoned to make a mention, my lord. My lord, I have already mentioned this matter before this honorable court. My lord had directed that matter will be listed on 1/9/2025.
What is the urgency now?
Urgency is on the 3rd. The matter was listed today, but in another bench, my lord. Inadvertently, it was listed.
Correct. What is the urgency?
Day after tomorrow, the matter. I have the hearing before the SLSC, my lord. The caste certificate hearing, my lord. Day after tomorrow.
It has to come before me.
Yes, my lord. As per the assignment.
The court has said that.
Yes, today only the matter was listed on.
And they said it here.
No, they said that it is not assigned to them.
Take that tomorrow.
Much obliged.
Special notice also there, but it is not received.
Yeah, you must call them, ask them to bring the file, the students' matter.
Yes, I have called.
Yes.
Much obliged.
So, first one matter.
First one matter.
Item 31.
31. So item 31 also can be short pass over.
You want pass over?
Yes, your lordship.
Second pass over. Can we have it some other next week?
Yes, your lordship.
Next week at the request.
Interim order is there.
Interim order to continue till next date only. But you need very good.
Item 41.
Could you go through that Based on Evidence Act?
Based on Evidence Act, my lord, what it says. No. Like what it says actually, so far as this case is concerned, my lord, at different stages, they have not nowhere said that they will not give it to us.
No, they are asking more money.
More money.
Condition.
Yes.
Number one, you have a appeal task now.
I know.
You want to execute the agreement. You want specific performance rate.
No, not the first one, even the second, what they raised the demand in 2005.
Correct.
When the execution.
Yes, you go for a specific performance.
The only
for specific performance. Why writ petition?
No, my lord, I'll just clarify why, my lord. The writ petition, the reason being, my lord, when we submitted before them that we are ready to pay it.
It's all right. You have to answer my question. How can a writ court grant orders for specific performance of a contract?
No.
What is that specialty?
No, my lord, I'm not seeking the specific performance of the contract in terms of the fact that the specific performance would have been had they not given me the possession.
Ultimately, that's what you want. No. Even for execution of conveyance, it's a part of specific performance.
That is true, my lord.
That's what L.C. Goyal says in his famous book, Law of Specific Performance.
So to that extent, my lord, of course, as your lordships, it fell from your lordships, that to that extent, so far as the quantum is concerned also. But the problem is whether the executing court or the civil court.
I will say civil court have full jurisdiction. I will refer to two decisions and I will say 68 Supreme Court.
So, yes.
Everything is open.
Everything is open.
What do you say? No, you have to save the limitation also.
Yes, ma'am.
Because all these years he has fought the limitation.
Yes, ma'am.
Because of you.
Yes, madam. Because of me. No.
You means
Yeah,
you means your client.
My lord friend was, my lord senior friend was blessing the
You are
agreement.
also senior to me now. We treat you as senior.
No, we treat him as senior at the bar itself.
That's one.
I address him as the designation,
Not making no difference.
he is like my brother, young brother. I worked with his father.
When I see him and you,
I have worked with his father.
I am saying something. Or there should be some humor also in the court. That's what complaint of the bar is. Humor is lost in the bar nowadays. All humor has gone to that bar. When I see him and you in a juxtaposition, it reminds me of Jonathan Swift's great work, Gulliver's Travel.
I can't help that, my lord. Really.
That's what, with due respect. When I was a student.
Before placing my case, my lord, I'll point out two things, my lord.
Even when I am saying this, you want to spoil that case, sir.
But my lord,
I am relegating him to civil court.
two points, only two clarifications only, my lord. One thing is, on the earlier occasion when the matter was there, I was also the counsel. The matter was before the division bench of the then Chief Justice. Another profound senior lawyer was arguing on behalf of the present petitioner. There the Honorable Court asked me, what is the price of the land? This particular dispute was before the division bench. The division bench asked me, what is the price of the land? I said, I can't immediately say it. Get instruction by over phone. I have obtained instruction. I have said that 2 crores of lakhs is the present prime market value. Then the court asks, what do you say? You do the matter. Nothing else. Second thing I am to draw your kind attention. Rule 54 of ODA rule. Odisha Development Authorities Rules 1983. That reads, lease or disposal of property at a value not below the market value, if any property belongs to the authority, is let out or disposed under Rule 52 or 53, it shall not be at the value below the letting value or market value of the property, as the case may be, such value being fixed by the authority. Therefore, keeping in view
that contention is available to you.
Rule 35, yes, to me.
How?
To me.
How that contention is available to you?
So that is the Development Authority rules. I cannot charge lesser value. What I have charged them, they have challenged in the earlier writ application. The Honorable Division Bench asked me, what is the...
You are repeating only. Repetition is... some author says very bad words. I can't use them.
I will abide by your lordship direction regarding the...
No, not the demand is not...
But what about the penalty and rent and cess, which I am going to pay, going on paying to the government and he is possessing the land. I have not yet received the price. I am ready and willing, whatever price your lordship fixed, I will override Rule 54, I will accept that money. But whatever the penalty and the rent and cess which I have been paying the government, because the land belongs to title, belongs to government, I am regularly paying the rent and cess. So that money he has to reimburse me.
Why you did not say all that in your agreement?
Agreement, yes, it has been said. I have
Where have you stated?
Yes,
show that.
And that amount is about 10 lakhs.
I am placing that agreement. From the agreement, I am placing that.
Yes, show that.
That the second party shall pay balance consideration of this month only first party on the basis stipulated by the first party. The second party shall pay penal interest on defaulted installment as at such rate determined by the first party.
Where did you determine?
Pardon?
Where did you determine?
I have determined in my annexures, in my notice to them as back as 38 August 91.
How much you determined? What is the amount you had determined?
Yes, ma'am. Ultimate amount is determined by Annexure 12.
But in the notice which you had sent.
Yes, that also I have sent. Annexure 12 is also notice. I have sent a series of notice. Annexure A by 2, B by 2, C by 2, D by 2, E by 2, and F by 2. And G by 2. These are all demand notices, including Annexure 12, which my friend was submitted. So from time and again, I am submitting that this is the final cost determined after the lease has been finalized with the government to emit the amount. I can't accept any amount lesser than the market value as per Rule 54. So therefore, my humble submission is Your lordship may fix the market the price of the land. I am ready, willing to accept it. Plus the penalty for defaulted amount and interest and rent and cess which I have going on paying to the government. Because title remains with the government till that. I am only a lessee. This is amount to sublessee.
But you have said government has permitted you
Yes.
to leave and make sale.
Yes, lease and sell. That is practice everywhere.
1 second.
Well, sorry.
You are going too fast without knowing
sorry,
correct
ma'am.
position of
Extremely sorry.
law. Under the Transfer of Property Act,
Yes, ma'am.
ordinarily it is the owner who will sell the property.
Yes, ma'am.
But there is doctrine of election.
Yes, ma'am.
I think under section 35, it is 35. Yeah. And there are other equity doctrines also, where X can sell Y's property, bequeathing or granting some value on Mr. Y. He need not be owner of the property.
Right, ma'am.
You have told that government has permitted me to sell this property. Therefore, I am entering into agreement to sell it. Therefore, I cannot take the decision. Is not wrong data.
I don't say that.
Government has given you blank.
I don't say that. I don't say that government is the owner. I can't fix that. I only pointed out your lordships rule 54. I can't charge lesser value than the market value as pointed out by the earlier division bench of this Hon'Ble Court, the earlier writ application.
You are only repeating that.
Sorry.
I am asking you.
Sorry, yes.
Where did you say that what I had fixed is less than the market value, and therefore you should pay higher amount?
Right,
That is not
right,
what-
right. I am coming to it. Well, I am again repeating, subject to your lordship's permission, my lord. Clause 2 of the agreement, which my lord friend was submitting.
Yes, kindly come to our agreement.
Yes, yes.
20,
Yes, 22.
23.
It's at 23.
Go to 23.
Clause 2. Page 23, your lordship.
Now I am asking you, since I have read this, please come to para 2.
Para, yes,
Page
my
2.
Clause 2.
Page 2. Page number 2.
Yes, my lord.
Below you have stipulated the price.
Yes, my lord.
It is only 3 lakhs.
1.5 lakhs as advance and 3.5 the subsequent. So
Subsequent,
total
4 lakhs it is.
5.
5 lakhs. 1.5 plus 3.5.
Yes, yes.
5 lakhs. Well, this is the amount you have fixed. Then you are told him to pay 18 lakh plus. Thereafter you said that no, 7.48 crore he has to pay. You go on singing different songs in different tunes. That will not make orchestra.
Hello, may I?
Read.
Yes, I am ready. I'm misplaced, my lord.
Yes.
Paragraph 2, that clause 2 said, the second party shall pay balance consideration of 2.5.
Oh, that's all.
Only the first party on the date of stipulated by the first party, the second party shall pay penal interest and defaulted installment as rate determined by the first party.
How can you increase this money?
True, I am coming. Subsequent paragraphs, my lords. The second party shall pay first party in addition to the cost of site, excess amount, if any, towards increased cost of land, development, rent, taxes after final costing of the total schedule is determined by the first party. So this is prior to determination of final costing of the land. 3.5 is prior to determination of final costing. The second, then point number 4, the second party shall pay yearly approved ground rent, etc., to the Tahsildar. Then ground number 5, the second party shall pay all revenue, ground rent, taxes, assessment, duties to Rauka municipality and other government department. That in compliance of the terms and conditions of this agreement and on full payment of the entire balance consideration interest thereon, if any, within a time stipulated by the second party, the first party shall, at cost of the second party, execute a registered deed of lease cum sale. And so subject, that is also lacuna, I do concede, this is subject to lease by the government, that is done in 2005. This is done 89, but subject to 2005, the government, after leasing out by the government, after final price has been fixed by the government, then I'll make the final cost of the land.
Sir, he has made out a case now.
I'll just take your lordships to that final, my lord, what is the calculation at annexure 5?
Yes. Because He is drawing our attention
Yes.
to particular paragraph which part of was missing.
No, my lord. That's why, my lord, I was pointing out at that point of time also. So your lordship might come to Annexure 5, 11/4/2005, when the calculation was made by them.
But why did you withdraw the petition?
No, because we wanted to pay it and get rid of
After
the
how many years?
litigation.
After 14 years.
My lord, if I have to pay, then we'll be on that amount.
No.
If at all the penal interest or
it's not
whatever
that-
the amount.
No, it's not that simple. This is a writ court. Writ is an equity remedy. It's like King's Bench, perhaps Queen's Bench. It's there. Equity. You ought to have taken permission of the court. Sir, for all these years, I have kept the matter pending. Of course, court had also kept the matter pending. You should have said, decide the matter on merits.
My lord, I can't go back, turn the clock back. But the question is, my lord, if at all also that is to be taken, and if I go by the terms of the agreement, then that amount should have been on 18 lakhs.
Correct, but best way, because of apex court decision, the best way appears to be, I do not know. If you say
Subject.
I should decide it, I will decide it.
No, my lord.
Now. Or you think that also. That you can make the request for withdrawal of the petition with liberty to institute a appropriate suit proceeding, keeping open all contentions of the parties. Because if I write something, tomorrow it should not reflect, it should not come in the way of your suit also. Think about that.
I fully agree to your lordship's proposition. I don't have any.
Give a memo.
I'll do that.
Yes.
One thing can I more propose, my lord?
That I should decide the price.
I'm not standing in the way, my lord. But your lordship has already culminated your lordship desire, my lord, accepted by Lord Fed. I am not standing in the way. Whatever I am submitting, my lord, I am a public sector undertaking. I have no own source of money to pay my staff. I will generate revenue from these lands.
Then you quote the money. I will tell him, consider that. I will not decide because
I'm not on that point, my lord. My hands are tied under Rule 54. I can't do anything. But I'll abide by your lordship direction. That much only I've said. But what further I'm submitting, my lord, I am a public sector undertaking without my own finance, no finance. I raise my finance from these transactions and pay my staff. And admittedly, they are using the money, they are using the land, they are in possession. Let them pay some more money as a condition for withdrawal so that I can get some more money, my lord. Because rightly or wrongly, today my demand is 7 crore something. So they must pay something for withdrawal so that I can get some money to pay my staff.
no, then he will ask me what authority you have to make payment to his staff.
Not to his staff, my lord.
No, your staff.
No, not in that way, my lord. I generate revenue from these transactions.
But what can be done?
My land is in his possession. I am paying the ground rent and taxes.
Therefore, you come, what I suggest is, you come. You want him to withdraw the petition, and still I should impose a condition that he should make the payment. How can that be?
I can't bring any proposal from
Stop that. Therefore, I am suggesting you. Now you have made out a particular point.
Yes,
which perhaps will impress him also. Instead, years have been fought.
But from 2007, first consumer stay order, then first writ application stay order, then second writ application again stay order. So I have got some money. That's my only payer. Not that I argue on that particular point, but in the process I must get some money. From 2007 2025, he's enjoying the land. I am not getting a pie. I am paying the land revenue tax every day, every year to the government for this land also. Because government is the title holder. I am the lessee. So some money
Not
will take to me.
subject to your lordships, and also being considering what my learned senior is saying. So far as the cess and rent is concerned, whatever the calculation they have given, because that's about 10 lakhs. It's not a huge amount also. So along with the interest also, if they want, I can deposit in their account so far as their statutory obligation is concerned. So far as the land valuation is concerned, which would be the subject matter of the suit, so far as in terms of the agreement, then their fixation of the price in 2005. and subsequently enhancing it to 7 crore.
No, there is some provision which
Rule 54.
Sir has pointed out, Rule 54, plus in this very agreement itself, there are clauses. Yeah, it is not that simple agreement to sell.
No.
It's a little more conditional.
So that is why-
retain power.
So that my lord, that is why I said. So
And
that
you have taken an interim order throughout earlier round of litigation for 14 years. Then one fine day you withdraw that. Then thereafter they issue this additional demand. You file, of course, new cause of action. You file it. It's your right. But equity now, many aspects are involved. Many aspects are involved.
Rule 54 can have a glance.
I believe you.
No, I've been the book.
It says
It's
you
as old
cannot
as-
alienate a property at a price lesser than the market.
The book is as old as you. Well, don't have any comment upon.
We are all going to be old only, no issue.
Rule 54.
Properties which have been purchased in persons of in shall as far as possible be used for the execution of the thing. Any property which required is for the purpose of that authority will make subject to any direction by the state government. Utilize, let out, dispose of the property in such manner and subject to such terms and conditions as the authority may consider expedient. I will permit him to withdraw the petition.
Yes, my lord.
And he wants to show bona fide so that he can make that bona fide a ground in suit.
Right, my lord.
So instead of paying this, that, etc., you deposit 25 lakh rupees with them. Then
As
fight the suit. All
as your
the
lordship.
tensions I will keep.
As your lordship.
That will help everybody.
As your lordship.
Understand? But only thing is,
Yes, ma'am.
you should not use that money to bring Palkhiwala to fight your case.
I
Which is depositing.
am with them. I am with them since 1986 from my senior's time.
Just write down them.
I'll. Terms your lordships can fix. I'll just give a memo
Yeah.
to that extent.
This matter was heard for some time. First, since the list largely operates in the realm of law of contract, in the light of Apex Court decision in LIC of India versus Exports Limited, AR 86 Supreme Court, the remedy has to be worked out in a properly constituted civil suit. More particularly when the disputed fact matrix is involved. First off. Next paragraph. During the course of hearing, learned senior panel counsel appearing for the Development Authority, Rourkela Development Trust or Authority? Trust. Sorry, authority. Can you be seated? Can you sit not? It's a Rourkela Development Authority. Development Authority. He expressed the difficulty which his client has been facing because of long pendency of earlier round of litigation in WP number?
Yes.
Sit down and answer.
2007.
So and so. And followed by the petition at hand.
One consumer proceeding was also there.
In addition to some consumer dispute.
Yes.
Consumer dispute. So he also tells the court that the authority is not in a position to meet to pay the salaries or wages to its employees, and therefore some arrangement should be made before granting leave to withdraw the petition with liberty to agitate the cause before the civil court. First off. Learned senior advocate appearing for the petitioner on the instruction of advocate on record submits that his client would deposit a sum of rupees 25 lakh with the respondent authority to show his bona fide without prejudice to contentions that would arise in the contemplated suit. First off, to this proposal, learned senior panel counsel appearing for the authority fairly agreed. Can I read that way?
Yes, sir.
He agreed.
Only
Agreed. But without prejudice to anybody. You will hold that money.
That earlier statement that
Time period, my senior wants that 25 lakhs to be deposited within a.
That I will do with the principal if you agree.
Yes.
That particular period I will say.
in the earlier sentence, I beg your
Why this
lordship,
suggest-
in the earlier sentence, so my submission is it shall not be negative, it shall be positive. You are not able to pay his staff, it should be able to pay his staff, not negative.
All right.
But lordships can rephrase the statutory payment so that that will include everything.
It can say authority will be enabled to pay statutory dues, including wages for salary, right?
Yes, ma'am.
Wages and salary to its full employees. That will structure that. First off. Fairly agrees. Fine. Next one. In the above circumstances, and one sentence you have to prove. Learned senior advocate for the petitioner puts a caveat that this deposit should not prejudice his contentions in the suit in contemplation, and that the same should be subject to outcome of the suit. First one, even to this proposal, learned senior panel counsel cottons with. First one. Next one. In the above circumstances, this petition is disposed of, reserving liberty to the petitioner to institute appropriate proceedings for working out his remedy, in accordance with law. First of all, while computing the period of limitation for bringing suit or other proceeding, the period spent in the 3 rounds of litigation, one in 2 petitions and another in consumer dispute, shall be liable to be discounted in line with Section 14 of the Limitation Act 1963. First off. Next paragraph. To draw benefit under this judgment, the petitioner as undertaken shall deposit a sum of rupees 20 lakh, 25 lakh with the sole respondent. With the respondent.
The state is there in the
respondent authority.
Respondent.
Authority within a period of 6 weeks. 6 weeks, all right?
Yes.
6. First. Ordered accordingly, and petition is disposed of. The undertaking given broadly covering the content of this judgment is filed by learned counsel on record for the petitioner, countersigned by, after serving a copy on the panel counsel. Yes, sir.
One thing, your lordship, if your lordship so likes, can waive the prior notice. Condition of prior notice. They have before we initiate a suit, they have to give a
Section 80 notice again.
So that your lordship can waive. My concession may have been noted, but it has to be waived. But he will face difficulty.
Yes, I have to notice of under section 80 and then.
Now that this
Section 80 may not be applicable.
State is a party.
If you want to file a suit,
Suit
State is a party.
it may be a necessary part.
Because under the
because they are the original, not the owners. So
I don't remember exactly the section, but there is a provision under ODA Act. They have to give you a prior notice for initiating the suit.
under the ODA Act also.
I can't even exactly say the section.
The apex court say
Yes.
the court where he brings the suit will have power to dispense with.
Dispense.
Because section, kindly read it. After 1976 amendment,
Right.
section has undergone, just let me see, I also, my memory sometimes.
Section
is very
83, I
tricky.
believe, is the dispensation.
Correct. There is a provision in this, sorry, 76 amendment.
82.
Huh?
Subsection
Section 2 of section 80.
80 is the waiver power. That application will make, my
will
lord,
make that
because of these contentions that can be, lord.
But just some facilitative observations I will.
As your lord.
Learned senior advocate submits that the client may face some difficulty in complying with section 80 of CPC 1908 in as much as arguably the contemplated suit has to be preceded by the notice. First off, notice, and therefore this court may dispense with such a notice. First off, this court does not see any difficulty in the proposition in as much as same relief can be had at the hands of the court before whom the suit is being brought. There are two judgments. One is the Justice Dhawan's judgment from Allahabad High Court and Justice Enlaw's judgment from Delhi High Court. They say, court before whom suit is brought, that alone can dispense it. Anyway, that's for the youngsters I am telling you. You look into that. Okay? First, just make it part of this and catch the judgment.
I'll give the memo, my lord.
Very good, very good. Kindly give that memo. I was under the impression that you did not have much defense at all. You turned the complete board itself now.
My friend's presence, my only what happened at the earlier occasion, my only witness, I can't bring in. Because
he joined the larger world now.
Yes, his predecessor is Justice Narasimham. So I can't.
Thank you. Yes. Yes, brother, government.
Mr. Notice item 1.
Your my lord, petitioner applied for the admission to B.Ed course, my lord. B.Ed course in 2025-27 for the session 2025 2 years course, my lord.
2 year course.
2 years. Selection was made by through state selection board, my lord. I was selected and an institution was allotted, my lord. Annex of 3, page 26, an institution was allotted in my favor after being selected, my lord.
They had allotted a seat to
allotted an institution. There I have to go to institution and took admission. And date was fixed to payment 26th of August and to 30th August.
Between these 4 days.
I have to pay the fees so far as the admission is concerned. And for admission, there are 2 dates, 30th of August and 1st of September. I paid, my lord, on 30th of August and I got the acknowledgement and also the receipt that I was selected. But I was not refused to take admission on the ground that I was not having the Oriya subject qualification at the 10th examination, my lord. Though the brochure says, the admission brochure, my lord, it says a student is required to pass Oriya, having Oriya subject up to class 10. I passed in class 8. I have submitted the documents, my lord.
1 to 8 you studied.
No, Oriya is one of the subject. Well, can you see that brochure, my lord, for that language, my lord? They are page 36. What they are saying?
No. Does it speak of studying it as a subject or as only the medium?
Oh, as a subject, my lord, as one of the subject.
As one of the subjects.
My lord.
Where is that? Just show that.
Page 36, my lord, can you see? That brochure, my lord. Last, my lord, clause 3 eligibility. Last, my lord, last can you see? C/he must have passed Oriya as MIL up to HSC or equivalent level or
have passed Oriya as a subject in the specific examination conducted by BSc.
My lord. I passed, my lord.
Any higher examination. You passed in?
I passed, my lord, page 21. I passed Oriya in class 8 conducted by Board of Secondary Education, my lord.
But that is not up to HSC.
That is up to HSC, my lord. That is HSC is up to class 10.
Correct.
I passed in class 8.
It is not up to 10.
Up to my submission that, my lord, up to class 10, 8 is within class 10, my lord.
Oh, it cannot be like that. Say duration.
My lord, can you see the brochure, my lord? Can you see the brochure? What is 36? He must have passed Oriya MIL up to HSC or any equivalent level or have passed Oriya subject in specified examination conducted by BSc, Orissa or
all this will not apply to you.
So there are two conditions, my lord. One is for HSC and is up to HSC. One is for Oriya with HSC and Oriya having Oriya up to HSC. Because by the same selection board, they published another advertisement for the recruitment. They said class 7 student with Oriya can be considered.
No, such an interpretation will defeat the very provision itself.
But can you see this same selection board, they published another advertisement for different posts, having BEd is one of the qualifications. What they said, taking the, can you see for a moment, my lord, page 40, 51, page 50, can you see 49, my lord.
Anyway, today is the last date.
My lord.
You take emergent notice.
My lord.
You are already before the court. Let us see what they say.
One seat, my lord, otherwise they will fill.
Issue emergent notice. Who appears for
state
AGA?
1, 2.
As it has been mentioned, so we don't have any copy. Let them serve a copy by that.
I've already served. I will serve extra copy.
AGA, Mr. Monty is requested to accept notice for all respondents.
No, 1, 2.
1 and 2.
And 4 also. 4 is a government college, man.
1, 2, and 4.
3 is state selection board.
Emergent notice to 3. First time. Next paragraph. Permanent counsel for the petitioner submits, and this court broadly agrees with the same, that the petition may be rendered infructuous if at least one seat in OP number 3,
OP4 institution.
OP4 institution
BEd course
is not kept vacant. One seat for BEd course is not kept vacant. First. Therefore, OP number 4 is directed to keep one BEd seat vacant, so that if the petitioner succeeds in the petition, it can be he or she, he can be accommodated. First time. Mr. Monty is requested to telephonically inform his client about this interim order immediately. Get that in order. Let me try to drop six over. This order is made at 2:35 p.m. today. Okay.
Can I get uploaded?
Yes, yes, I'll get it uploaded. You also speak to them. The court has made this order. Okay, Mr. Mohan, see that because they may say it's already over. Yes.
Item 42.
2 weeks after my friend, I have to file in 2 weeks after my lord. 42 item.
What do you want?
I want to adjourn for 2 weeks after because I will file rejoinder. And apart from that, I have to file an affidavit that opposite party number 2 and 3, who are the responsible party, though the notice is sufficient, I have the acknowledgement received. So my
2 weeks.
I am opposite but number
You appear for?
opposite but number 4.
interim order continue.
Interim order to continue till next week or call up the 3 weeks. So, yes.
Item 43.
43.
Item 43 may be taken up next week.
43.
Yes, Mr. Mishra, senior advocate, will appear. He is on his election undercourt.
Mr. Mishra was here now.
Yes, he is on now. Is in election undercourt.
He is under in another court.
Also, next week any day also.
The lawsuit kindly have a glance through, or I am appearing for opposite party.
You are also appearing for. You are for.
I am for petitioner.
But let us hear Mr. Mishra and then.
Any day
pass over.
Any day next week also.
No, because I have to upset so many things now. Just after he completes the work, we will wait for him.
No, he was also seek for adjournment because he is also not ready.
No, only questions involved in this case whether writ application is maintainable.
But in his absence, how to dismiss the petition?
He confident.
He is competent definitely, but he is saying my senior has to argue.
Let it pass over.
No, I made the same proposal.
Any day next week also.
If you are very sure that it will be dismissed on that ground, 1 week makes no difference to you.
Oh, there is of decisions are there.
That's what.
MSME award has been challenged on Article 226, 227.
They cannot
be. Because alternative remedy of appeal under Section 34 of the Arbitration and Conciliation Act, they are there.
No.
That is the verdict of the Supreme Court, that the verdict of this Honorable Court. Various decisions are there.
You can say all this in the presence of Mr. Mishra, your friend, so that he will be able to answer. I am in agreement with you now. But if he does not agree, if he has impelled some contrary judgment.
Very interestingly, my lord, before this Honorable Court, Mr. Mishra appeared for opinion number 3 and raised the contention which I am raising here.
Because in that case, his client has instructed him. In this, he may not instruct. Let us solve this matter from day to week of week of next.
Short date.
Yes, very short. It should be 2 digits. 25th of September. Yes.
Interim order to continue.
Interim order to continue. Still shorter you want?
Yes,
23rd you can have.
Yes.
All right. 23rd. Right? Finally. Interim order to continue till then.
Obliged first.
Yes, the question. Item 44. 44. Item 44. Yes, sir. What is this matter about?
Yes, as I tell your lordship, annexure 9 is being challenged before your lordship on the ground that it's an order without jurisdiction. It's a nullity.
With permission of my friend. But before he begins the matter, let me tell your lordship 2 minutes. This matter was heard. So initially the court was on the impression before hearing me that the writ is maintainable. Subsequently, after hearing me, the court insisted the other side, my friend's client, that why don't you approach under Section 34 to challenge the arbitration award? it was stated in the court that a 34 application has already been filed.
It's filed.
Right.
Interesting. Challenging the very same award.
Right. So once you file the 34 application, now the writ is pending. Simultaneously, same order cannot be challenged in both forums. 54 Supreme Court is staring. Therefore, my respectful submission will be either he has to forego that, then come the writ, we'll hear it on merit, or he has to withdraw the writ, pursue the heir.
I'll respond to that. Let him, wanted 2 minutes, let him complete. I'll respond to that.
Is it due? Your 34 is pending?
Yes, my lord. After the writ petition was entertained here and interim order was passed by your lordships here, an application under 34 was filed essentially to meet that deadline. Because your lordship knows if a 34 application is not filed within a particular date, it cannot be filed. It was filed only to meet that deadline. The petitioner still submits before your lordship that this application under 226 is maintainable because what is being essayed before your lordship is an order which is a nullity on the face of it.
That contention is available even in 34.
Yes, my lords. Now, my lords, for that, there are a number of judgments which I rely upon, starting with Municipal Council, thereafter Royal Sara Lee, even your lordship's judgment in withdrawal of judgments on this point of this honorable court. Now, my lords, this was in fact on the very same question before this honorable court, and a coordinate bench of this honorable court has held that notwithstanding the alternative remedy, since the court has not addressed the issue on maintainability of the case, it is to be remanded back to that court or the forum to decide whether the proceeding before it was maintainable or not. Now, just 2 or 3 documents I will show to your lordships before I take your lordships directly to that judgment. Your lordship may kindly see
now you have some interim order here.
Yes, my lords, I have.
We'll continue that interim order and you fight that.
My lords, may I just say, my lords, by the only contention of the only other difference the 34 application would make is my making a pre-deposit. My lords, I have instructions of my client to state that I will make the pre-deposit here before your lordship. But your lordships may hear my 226 application because on the face of it, kindly take page 123. Kindly, my lords, for a minute.
Then you deposit, then we'll hear you.
Yes, my lords. I'll
deposit that money
here, in this honorable.
Sir, before he deposits the money, can I have a look at 54 Supreme Court, sir? 54 Supreme Court 207. Paragraph 4.
He has raised the question of maintainability. Let me argue on the question of maintainability. I will satisfy what I
see. 54 Supreme Court.
Right.
357.
207.
No, 357.
357.
Yes.
I may be wrong.
Yes. 54. That Kiran Singh versus.
The income tax.
No. Kiran Singh versus.
What I think. Forget the reason.
1954 Supreme Court 357.
Paragraph 4 is what I understand.
Your judgment is different. I remember that judgment also. This judgment is by 3 judges. I think that is also by 3 judges only. The one which you are quoting now.
Constitution bench judgment.
5 judge.
Paragraph 15 onwards.
Kindly read. So that many students will be here eager to hear both stalwarts.
So it says,
I am also interested.
Sir, K.S. Rashid and Son versus Income Tax Investigation Commission, AR 1954, Supreme Court 207. A constitutional bench of the Honorable Supreme Court considered the issue that when the remedy under Section 8(5) of the Taxes and Income Tax Investigation Commission Act 1947 has been pending, whether the High Court could entertain the writ petition. The Honorable Apex Court held that person may choose or effect where it will proceed with the alternative remedy or with the writ petition, but both cannot be pursued simultaneously. It would be advantageous to reproduce paragraph 4 of the aforesaid judgment. It's paragraph 4 of that 54 section.
It's a famous judgment. Everybody has read that.
So that is the reason I say that he is to choose.
Plural remedies he cannot pursue.
It's pending.
That's what.
If it is not pending, I can understand. He will deposit the money here and proceed.
Well, I am not pursuing that remedy. I am pursuing the writ petition. I have filed it only for the purpose of saving the limitation because otherwise that relief would be obliterated for things to
He is
come.
correct. He is correct. Let him tell the date of order, date of filing of the Section 34 application.
Date of
If
what
that is correct.
Yes, let us see.
Date of award, date of filing of Section 34 application.
By that time it was time barred.
Yes, sir.
Then
Your Lordship may call for
Therefore,
Your Lordship may call for that office note from the appellate authority.
Therefore, the
34
question of
records, therefore.
saving the limitation and filing it may not arise.
My lord, your Lordship may call for the office note from the commercial court.
This
That will-
petition, one second. Whether this petition was filed within that time.
Yes, my lord. Yes, my lord. It was filed.
When the award was made?
This award was made on 9/8/23. This application was filed on 16/10/23.
WP.
So if that is so, in the writ petition, why they didn't disclose it?
No, it was not in existence then. It was only after the interim order was passed in the writ petition, just to save that 120-day delay, 120-day cutoff mark, the 34 application was filed. And this is a piquant situation, my lords, which was not before the Constitution bench who have considered that I cannot pursue two remedies together. This situation was not there. It's a situation which is piquant to this fact situation, my lords.
No, doctrine against pursuit of plural remedies.
Yes, my lords.
Applies.
I'm not pursuing that remedy because that, my lords, my humble submission would be here, my lords, that application to save limitation was filed. I am not pursuing that because that application has not yet become competent. It will become competent once I make the pre-deposit. Because till the pre-deposit is made, the application under 34, read with section 18.
It is no application.
Is no.
That's all right. But when you had an alternative equally efficacious remedy.
Because of the law laid down by the Honorable Apex Court, that where the order on the face of it is without jurisdiction, I have come up before your lordships and your lordships have indicated me my stand, my lords. And this has been the law which has been laid down by the Supreme Court in 64 Supreme Court. It has been reiterated in Whirlpool, again reiterated in Sarali. Your lordships also have followed it. And my lords, your lordship.
So that has been taken care of by the Supreme Court.
And my lords, here is a case where the matter is heard by A, B, and C. The order is delivered by A, B, and Z. A person who has not even heard it.
Mr. Mishra, is it true? It was an arbitration tribunal.
Sir.
Tribunal, the House of Lords said, tribunal comprises of A, B, C.
Right.
And one of the members of the tribunal sleeps. The House of Lords said, it is no tribunal and therefore the proceedings are
non-est.
This is not a case here.
No, ABC.
No, it's not correct.
I'll show you. I will show you.
And what other ground do you have?
This is one ground. Second is that this is what
with due respect,
the government is ready to supply.
With due respect.
Sir, no, that contention, I'm afraid, because it is mixed question of law.
No, it is not. It is an admitted position and is borne out from the award itself. Admitted position.
Sir, the question is a person who
your lordship kindly says page 123.
Contests the arbitration proceeding. Who contests the arbitration proceeding participated never raised a single word with regard to either jurisdiction or that is not a MSME registration or any other ground of technicalities.
No.
Yes,
That is
not only
whom
contested.
it was referred.
Sir,
Tribunal comprised of whom according to order?
so tribunal comprises of the conciliators
Yes.
who are become the arbitrators. 5 persons were there.
5 persons. Whether these very same persons were the authors of the award?
Yes, sir, just a minute. Same persons were there. One of them, his term was over. The other person joined because 4 persons are there. At that time, award is also final. The award was final.
No, one person retired during the mid of
That
the
is
proceedings.
mentioned in the counter. The majority view is 4 persons have already signed it.
No, question is not majority. Question of majority arises where tribunal is properly constituted.
So here the question is not heard. Award was final.
Your Lordship may kindly see 2 pages only, page 123 and page 155.
This discussion is to understand what
What I beg to submit is, so this was not the situation in fact. So in the REIT application also kindly see, the first time all these points have been raised. First time all these points have been raised. It was also open to him to raise it before on section 34. Jurisdictional point also can be raised before on section 34.
That's true. But where matter is there, that's true. That does not bar me is true.
Right.
But where it's a jurisdictional point, which can be adjudged on the base of the record itself.
Can be seen.
They can
be seen. Here, after hearing the matter, I also that this one also. The question of jurisdiction they are raising has already been referred to a larger bench, holding that they have the jurisdiction. It's already there on record. So here the question, a person cannot just come forward and say, the decision they are citing is also, it has been said that it cannot be referred to. The question of law.
Since 54 you are referring to.
Yes, sir.
I refer to that Kiran Singh versus Charanjit perhaps. No. Chaman law.
Right.
Chaman Paswan, 54 Supreme Court. It says, if an order or a decree is passed without jurisdiction, its execution can be resisted even in collateral proceedings.
Even at any stage of the proceedings.
At any stage of the proceedings.
Right,
because he may refer to that also.
So he may refer to, so the question is, that jurisdictional point can be raised on section 34.
That's true.
Section 16 is there.
All contentions are available. But law of certiorari, the alternative remedy, recognizes one exception. That is writ of certiorari. 3 exceptions. One is writ of certiorari. There is a 9-judge bench decision on this, where apex court said, where writ of certiorari is sought, alternative remedy cannot be the sole ground for resisting the petition.
So it is not that manner. Here the Supreme Court has held on section 34 MSME Act, whether an alternative remedy can be availed or not, or whether, even if there is alternative remedy, whether writ is maintainable or not, is a question which has already been referred to a larger bench. This exact question, I'll show it just now, madam. So kindly have a look at it.
Law as it stands today, my lord, law as it stands today as laid down by the Supreme Court, it says that this proceeding is not maintainable. Even if the particular point, one of the points have been referred to a larger bench.
Is this?
Is one of this. One of the points that on which I lay this writ petition.
So what you say is, perhaps what you want to say is, merely because a decision is referred to the larger bench,
it does not become bad law.
Presidential value of the existing judgments is not.
That is why the
judgment will not be treated as a precedent.
Is it? When matter is referred to larger bench?
Yes, mother.
Is it?
I don't think that there is any law to that effect.
I am also not really aware of. On the other hand,
position at least never.
in English law by Rupert Cross, he says,
So kindly, that paragraph I have marked.
Indian glycol concentrate Indian glycol.
No, that is not, it's not held like that.
These are not treated as a precedent.
They are not treated as precedent is one thing.
Right.
A decision losing its precedential value because it is referred to the larger
Yeah,
bench is another.
that's correct.
Rupert Cross on English law.
So
English.
normally actually High Court restrains if a matter is pending in the
But correct. But on that itself there is divergent opinion now. Earlier view was where a particular point of law is being debated on the floor of the highest court of the country. The other courts and tribunals should wait. Then apex court say it is not possible, it is not desirable at all. Unless we stay, as it happened under Section 24 proceeding, that 2013 Act, where they said no court shall touch the papers where this question is pending. We kept quiet.
So can you look at the other reference? There are two.
Well, it's still have.
His hearing is going on. It's like Jagannath Jatra. In a way, where we get some devotional knowledge also.
All the documents are there for our board, in fact. That reference part, last paragraph.
That's what Mr. Mukherjee also said. One of the points that arises for consideration. Anyway, it's a debatable, but not that order is ready, that the students are matter. You would give the doctor. Yes. Yes.
The Lordship still hears the matter.
Well, it's, there's one more thing which I wanted to bring to your Lordship's notice. In fact,
first point you said.
Yes, Manoj.
The tribunal was not properly funded.
Yes, Manoj. That your Lordship, just 2 pages I'll show to your Lordship. Your Lordship may turn to page 123.
Go to 123.
Can I get the comparison I gave?
Sorry, that's all. Take this.
It is there on the Lordship's record.
But on your proposition, that once it is referred to this one, that will lose its precedential value. I don't think that there are 2 books on this.
No,
one is President.
I have also cited those 2 books.
You have cited?
Yes.
Very good. But the President in English law, Rupert Cross says, merely because a decision is referred to the larger bench, it should not become destitute of precedential value. I am just reproducing that sentence.
I have given those judgments also.
Yes.
I have given a note, in fact. Judgments are also there.
Your Lordship takes page 123.
Once, on point of law,
yes,
I want to have clarity. Point of law, anybody can argue. On facts, yes, it is your prerogative because you are the dominant treatise. That be. On this proposition, Mr. Mishra wants to say that it becomes, it is not binding at all once that judgment is referred to on that proposition.
No.
Not that, but of that proposition I would say. Because the President in English law, Professor Rupert Cross treats that point. And the President in Indian law, by Professor Lakshmi Kanta, he has also treated. Therefore I said that. It's an Indian version.
I have given judgments to the contrary in my list of citation. It says that it has to be followed as long as
it is not reversed.
I have also relied on that. Refer to that also.
Sir Mukherjee.
Yes, Manoj.
Which paragraph you said?
No, page 123. 123. The composition of the tribunal. Your Lordship takes note at page 123, the composition.
Sadiq Kalam.
Alam is the chairman, Gautam Patra and Mr. Deepak Kajaria.
This was the
tribunal. Now kindly take the final page, page 150.
Members were present.
Yes, these are the person who heard the case, present. And now kindly see who has signed the award. Page 155.
155, my lords.
One second. That award is signed by whom?
That is at page 155.
Dipankara Mohapatra.
He is not there. At page 123. And the person who is there, Deepak Kajaria, is not here. That is why I submitted to your lordship that A, B, and C heard, A, B, and Z delivered the judgment.
Z came on the scene when? No, you appeared before in the proceeding.
I never heard. This Dipankar Mahapatra was never there when the case was heard.
How many times matter was?
Once. List of dates, yes. Kindly see the list of dates. That is another point that I will argue before your lordship. This, the quietus has to be put to this tribunal, my lords. When the way it is being functioning in Odisha, the quietus needs to be put.
Those who heard are different from who
delivered the award.
That is one point.
That is one point.
Yes.
The second point is also at page 123.
How tribunal is constituted under any separate act? Is there MSMT?
There is this act, MSMT Act.
It borrows Arbitration Act.
It has to adhere to the principles of Arbitration Act, and the Supreme Court has said the entire proceeding has to be in consonance with the provisions of the Arbitration Act and has struck down proceedings which have not adhered to the principles of Arbitration Conciliation Act. That is also another point that I will be arguing.
Arbitral tribunal is defined. Is it arbitration?
Yes.
I do not have much exposure to
Yes,
MSME Act.
Yes, ma'am.
Any arbitral tribunal is defined.
Yes, ma'am. The establishment
Section 18.
Section 18. Well, it's the council.
Your client never appeared before the tribunal comprising inter alia of Mahapatra.
No, never. He appeared like a GD on the award. The Constitution was the who are the members of the defense team.
How many sittings happened?
Page 127, your lordship may see.
Page 123, the history of the case. 127. History of the case.
The history of the case begins at page 123. And
meetings were completed on 19th May 2022. 27. And it's in 96. 96.
your lordship may take bottom of page 126.
126.
Yes, my lords. Your lordship, take the last paragraph. The council directed the opposite party number 2 to file counter before the next sitting of the council and send copy of the counter directly to the petitioner under intimation to the council. The case is adjourned. Notice has been issued to both the parties to attend 96th sitting of the tribunal to be held on 12/10/22. Both the petitioner and opposite party are present at the 96th sitting of MSME on 12/10/22, the council started hearing the case under section 18(3).
Now come back to page 123.
Now kindly come back to page 123.
And this is the members present on 12/10/20. 123.
Page 123. The council, kindly see, the MSFC met on 12/10/22 at 10:30 a.m. to adjudicate the claims, and the members following are so and so. And that was the date on which the matter was last heard.
All right, 1 second. This composition
Yes, my lords.
was altered on which date?
We do not know, my lords.
Why? You have appeared before so many places.
We appeared before 1, 2, and 3 indicated at page 123. That Mahapatra was never there. And no further hearing took place ever.
After that?
Yes.
Mahapatra was there in only one sitting.
Never there. No, Kajaria was there.
But he has signed...
He has signed the award without ever hearing the case, whether ever being present in the proceedings. And that is exactly what had arrested the attention of this Honorable Court in another case where the Honorable Court has commented upon this. The frequent composition, the change in composition of the tribunal.
When you came to know of this?
Award? On getting the award?
After seeing his name?
Yes.
Yes, one first point is it was not a tribunal at all.
Yes, Maharaj.
Number one.
Second point now. Kindly come back to page 123.
The council that in terms of the order sheet,
the registration certificate?
More particularly at page 123, the arbitral tribunal comprised of Muhammad Sadiq Alam as the director, Shri Gautam Patra as the convener, and Shri Deepak Kajaria, director of Industries MD OSFC, Mr. Gautam Patra, convener SLBC, and Shri Deepak Kajaria, president OSSIA. 7. The said composition had heard the matter several times. 750. However, the award has been passed by a tribunal comprising of who retired actually Patra?
No, Kajaria. Kajaria is not there in the award.
Signed by.
He has not signed the award.
By Mr. Mahapatra, who was never a part of the composition. And Mr. Deepak Kajaria being absent.
And this award was delivered 8 months after the hearing was concluded.
First, he adds that the gap between final hearing of the matter and passing of the award is about 8 months.
9 months. 9 months.
9
months.
And that the petitioner had no idea as to how Mr. Mahapatra sneaked in. How and when Mr. Mahapatra sneaked in. First, therefore, the award in question is honest, and that can be challenged even in great jurisdiction. That's first proposition.
Yes, sir.
Second contention.
Second contention. Now let's kindly take page 123 again.
Yes, I'm at 123.
Yes, Manoj. Your Lordship takes the history of the case. The petitioner, so and so, is a small enterprise, number so and so, kindly take note of the date 16/1/2019 under DIC for supply of other professional, scientific and technical activities NEC. The petitioner supplied to the opposite party during the year 2016 to 18. He was not a supplier on the
date 16/1/2019.
Yes. On the date he executed my work between 16 and 18. He became a supplier post registration on 16/1/19. And his registration certificate, your lordships will get at page 66. So he does not fall within the definition of a supplier under the Act.
But the petitioner is opponent.
Yes.
Claimant.
Yes.
Next point. Drawing attention of the court to the heading of the award to inverts history of the case, comma. Mr. Mukherjee submits that. OP number
2.
OP number 2.
OP number 4. He is now the number 4.
Was not
a supplier. A supplier only can maintain the application under MSME.
Not a supplier, in as much as it could attain the status of supplier only with effect from 16/1/2019, that is the registration. Whereas the supply took place during the period between 2016 and 2018. First of all, this essential ingredient lacking, comma, award is no award. And therefore, matter warrants examination at the hands of this court, notwithstanding the availability of alternate remedy. These are the 2 points.
No, and this point was raised before the tribunal. He has not dealt with it. Kindly see page 77, para 1.
Next point. The point number 2 was urged before the tribunal as it was composed at the inceptio, ab inceptio. And despite that, the same has not been treated in the award document. 115. The third paragraph refers to 2.
And one more proposition which I would put forth before your lordship is that it is the mandate of law that a proceeding under this Act has to abide by the provisions of the Arbitration Conciliation Act. If it does not, it is liable to be set aside on that ground alone. And in this proceeding, as your lordship has seen from the order sheet, the day the written statement was filed, the hearing was closed, it was posted for orders, award, and the award was delivered after 8 months. So there was no opportunity given of leading evidence, there was no examination of documents, there was no examination to rebut the cross-examining.
The Mukherjee submits that the proceedings which culminated into the enthroned award before this court did not adhere or in gross violation of the provisions of 1996 Act. 1996 Act. Opportunity of hearing and no trial of the cause having taken place. Okay.
And the last point that I would make is that this is clearly, as is borne out from the purchase order, this is clearly a works contract. A works contract cannot come within the purview of the MSME Act. That again is a question which is pending before the Honorable Apex Court.
Works contract in the light of Gannon Dunkerley.
Gannon Dunkerley.
Lastly, the records demonstrate that the subject matter of arbitration involved a works contract in the light of Gannon Dunkerley, and therefore that would not fit into the parameters of 95 Act or this Act.
MSME Act, 2006 Act.
MSME.
It is neither goods nor services, goods and services. It's a mixture of goods and services. This has to be goods or services. It cannot be a mix of both.
In as much as it is a mixture of goods and services, as contradistinguished from goods or services.
These are broadly my propositions. I'll come up with case laws on each one of these propositions. Let me learn it, friend.
Any case laws for proposition? Just the case law.
Yes. I have already submitted a written note. It's there on the record.
You have submitted?
Yes, madam. It has been submitted with the
note. You are right.
They did have.
No decisions you have cited.
Yes, my lord. And besides that, my lord, there are two judgments of our own High Court, which I would first bring to Lordship's notice. That is, my lords, এটা বড় And it's the first judgment that it's a judgment of a coordinate bench of this Honorable Court. B.R. Sponge, Private Limited.
Paragraph.
Yes, my lord. So your lordship may come to page 11 of that judgment. The pages are at the bottom of the page.
Yes.
5 lines from the bottom of that page, sentence beginning to be a supplier.
To be a supplier.
To be a supplier.
Memorandum is to be issued by the concerned authority.
And in the instant case, the same is claimed to have been issued to opposite party number 2 in the year 2010. Admittedly later to the supply of iron ores to the petitioner. Thereafter, your lordship comes to paragraph 15. Midway into that paragraph, they quote Jharkhand Urja Nigam Limited, refer to Jharkhand Urja, and thereafter the sentence is, it is a settled position of law that existence of an alternative remedy is not always a bar to maintain a writ petition where 1. Such writ petition is filed for enforcement of a fundamental right guaranteed under the Constitution of India. 2. There has been violations of principles of natural justice. 3. The order or proceeding to be fully without jurisdiction. Or 4. The virus of the legislation is challenged. Thereafter,
they quote in Ehsan's judgment, we are conscious of the law that existence of an alternative remedy is not an absolute bar on exercise of writ jurisdiction. More so, when a writ petition has been entertained, parties have exchanged their pleadings, affidavits, and matters has remained pending for long. In such a situation, there must be a sincere effort to decide the matter on merits and not relegate the petitioner to the alternative remedy unless there are compelling reasons for doing so. One such compelling reason may arise where there is a serious dispute between the parties on a question of fact, materials, evidences available on record are insufficient, inconclusive to enable the court to come to a definite conclusion. Thereafter, over the page, my lords, at page 14, midway into that page, the sentence beginning, in case the opposite party, has your lordship's got that?
Supplier.
In case the opposite party number 2 is not considered as a supplier under the MSMED Act, opposite party number 1 in such a situation cannot have jurisdiction to adjudicate the dispute. As earlier mentioned, the question of having jurisdiction with the council was not raised or has ever been examined. Of course, this court does not have the comfort to go through the pleadings of the parties filed before the opposite party number 1. Even a question of jurisdiction, as it hits the root of the case, can be raised, entertained, and examined by the authority itself created under the statute. Thereafter, my lords, towards the end of that paragraph at page 15, page 15, fourth line from the top, if opposite party number 2
Not a supplier.
is ultimately held as not a supplier, in such an event opposite party number 1 cannot usurp the jurisdiction. And thereafter what the court does is at page 16. In the instant case, I'm reading at the top, my lords. In the instant case, the decision is required to be in place so as to if the council can entertain the dispute accepting opposite party number 2 as a supplier within the meaning of section 2N of the MSMED Act, and then only it shall have the jurisdiction and hence the matter needs a remand. In the case, opposite party number 1 itself holds itself having jurisdiction may also consider conciliation arbitration. Lordship may skip over that.
The learned judge differentiates between
Yes.
lack of jurisdiction
Yes, my lords.
and lack of jurisdictional facts.
Yes, my lords.
He oscillates between these two.
Yes, my lords.
In the case of lack of jurisdiction, we have no problem at all. It is much law settled since 100 years.
Yes, my lords.
Where lack of jurisdictional facts are involved.
There is no dispute in facts.
That's what he is. But he is oscillating between this, that. It's
Yes,
like
and that is why he remanded it for being considered on facts by the tribunal. Now, here is a case where the facts speak for itself. Documents speak for themselves. The fact remains that the claimant before the tribunal was not a supplier within the meaning of the MSMED Act. They have taken note of this fact, and this is one judgment. And as far as the tribunal change in the composition of the tribunal,
this judgment has attained finality, no?
Yes, madam. It has. This was
just
challenged before
whether it was put in appeal.
We'll check the authority again, but to our knowledge, it's not been.
It is not.
Check again, ma'am.
Just check it again.
There's one more judgment.
Any other high courts in the country have taken similar view? Of course, if brother judge has taken.
High Court has taken similar view. Supreme Court in Jharkhand Urja has taken a similar view. Supreme Jharkhand Urja, well, so that has been submitted in my
item number.
That is
10. Jharkhand Urja
169 of that compilation which I have given.
Item number 10.
Yes. Yes. Item number 10 and item number 2. These are two judgments.
Item 2.
Item 2. That is Vaishno Enterprises. The page go.
But Vaishno Enterprises is referred in with the judgment with Mr. Mishra cited.
It is referred to a large number of judgments, and then they have culled the points, Manoj.
Okay. In Jharkhand, which paragraph 14 and 19?
In Jharkhand, I'll just take your look. 14 and 19. 14 to 19. That is at page 177.
Can you just
170, I'll read out the paragraph. 74. Yes. Yeah. Your Lordship may take at page 211.
211.
Sorry, of that judgment, which is at page 174 of the compilation.
Section 18.
From a reading of section 18.2 and 18.3 of the MSMED Act, it is clear that the council is obliged to conduct conciliation for which there is a provision. Yes, Malad.
Next paragraph.
There is a fundamental difference between the conciliation and arbitration. In conciliation, the conciliator assists.
No, everybody understand. Go to next point.
Not appeared conciliation, the order is nullity. Paragraph 18. The order dated 6/8/2012 is a nullity and runs contrary not only to the provisions of the MSMED Act, but contrary to the various mandatory provisions of the Arbitration Conciliation Act 96. The order dated so and so is patently illegal. There is no arbitral award in the eye of law. It is true that under the scheme of the Arbitration Conciliation Act 96, an arbitral award can only be questioned by way of an application under Section 34 of the Arbitration Conciliation Act. At the same time, when an order is passed without recourse to arbitration and in utter disregard to the provisions of the Arbitration Conciliation Act, Section 34 of the Act will not apply. We cannot reject this appeal only on the ground that the appellant has not availed of the remedy under Section 34 of the Arbitration Act.
Paragraph 18.
Then, my lords, as far as the change in composition, that also has been commented upon by this Honorable Court. Kindly take page 18.
Page 18 of your paper book.
Of the judgment which I have just handed over. This is again a judgment of a coordinate bench. Page 18, conclusion. Paragraph 47 is important. Your Lordship may straightway. Page 19. The award passed by the MSCFC in the instant case shocks this court to its core. The frequent reshuffling of the council members leading to grave miscarriage of natural justice to the parties, the continuation of the proceedings for years together, when the statute in fact envisions disposal within 90 days, the reluctance in offering the route of conciliation to the parties, the sordid state of affairs are disheartening and self-defeating. This is also a case where the composition of the tribunal had changed, but it was recorded in this manner, not specifically. Yeah.
It is imperative.
Para 48, last 4 lines. It is imperative that some modality must be adopted to see that the composition of the council during the course of a proceeding remains unaltered to give a fair and level playing field to the parties before it. Paragraph. And here also the Honorable Court.
It was set aside 34.
No.
Huh?
Yeah, this was under 34. This was under 34, but the other one was in 226.
No, you are pressing into service this decision for what point?
For the purpose that once or tribunal consisting of a particular composition, here's the case, and some other. It is like arguing before a particular judge, having a judgment from a different judge. It's a gross violation of natural justice, Malad.
Here to decide.
The very purpose of hearing gets defeated.
Yeah.
That judge, With regard to the,
This matter also did not go in appeal. Again, finality.
this also has that infallibility. This, matter was remanded back, it went before the tribunal and the tribunal is now in session of the matter, I believe.
It is not yet reported. It's A for judgment.
We'll check.
That report to give now. Of course, the presidential value of a judgment does not depend on whether it is reported or not. A judgment is a judgment is a judgment.
Eight or 37.
Yeah. Any other point?
And with regard to the works contracting matter, there's the Bombay High Court judgment.
Dunkerley may not hold the field after amendment of the Constitution.
Directly under MSMED Act, page 144, Bombay High Court, my lords.
Which is that case?
This is
12 decisions you have noted.
Sterling, Wilson and Wilson Private Limited and another.
That is the line.
Yes.
Serial number 9.
Yes.
That is for proposition.
That is the proposition that works contract will not come within the purview of MSME. This is pending in 3.
4. Works contract. Write one decision then. Serial number 9 in petitioner's compilation.
And I also need to inform your lordship that this judgment has been assayed before the Supreme Court. It is pending, no stay has been granted. It is pending in Supreme Court.
This decision is being examined by the apex court. 136 it is.
130, SLP.
In itself. I know interim order can be states supposed to move to
That's good.
Thank you.
So one question I can answer today. I'll just refer to one judgment, sir. If your worship can have a look at now, your worship, that point your worship indicated that before registration under the MSME, I cannot be considered to be a supplier. So for the purpose of referring the matter to MSME adjudicating authorities, you worship indicate that point number 1, 2, or 3 is like that. But kind of have a look at the judgment of NBCC India. That is there in the compilation given by my friend. NBCC India with the state of West Bengal. Page 203.
CC. State of West Bengal.
Right. And turn to page 6, my lord. The page is at the bottom, my lord, in the judgment. 2.4.
Page number
6.
In a page 208 of that compilation. Page 208.
Or 208.
In the report page, I'm not seeing the compilation. I'm just seeing
in the report, it is page 6 on bottom, it is there.
Page 6.
2.4. Para.
2.4. You're right. Two point three, we have 2.4.
2.3 is it starts from seeking resolution.
That dispute was referred to arbitration. The appellant object with the 2.4.
The appellant objected.
Correct. To the facilitation council entertaining the reference firstly on the loan that is not registered and before the execution of the contract act as such. Apex court said even works done prior to registration may also come within the purview. Which is that answer? Where it is answered?
Sir, they have referred to that all those provisions.
Where is the articulation of the principle?
The paragraph 14.7.
14.7. Next. Mr. Mishra submits that an arbitral dispute may involve supply of goods or services even before the supplier was registered under the MSME Act. That's the proposition.
Yes.
Where is that answer? Where is that? Kindly read in support of that.
14.9, if your ship turns.
The processing to
Page 30.
NBCC versus State of West Bengal. Item number 12 is petitioner's compilation. And paragraph
14.9.
Paragraph 14.9. 14.9.
It says, inner page 30, minute.
Go to page 13. 3.
Page the bottom of the page, mark. Page 30.
Even 14.9.
Further, it is noteworthy.
You are right. Paragraph 14.9. The community accounts of the four features is company and which the application pay of will send to the cannot be taken from the state and the place had not registered itself in section 8. So registration is irrelevant.
Right.
It can be MSME, whether it is registered or...
Registration gives certain other benefits.
But for this, it need not be written.
For referring the dispute. So they have also discussed about the supplier 2N, read with section 8.1. I'll take your lordship to those paragraphs.
He submits that registration of an entity as an MSME under section is it under 18?
Sir,
registration is under 18.
8.1.
8.1 of the Act is for other purposes, and that the registration is not relied upon now for raising the disputes before the arbitrator. Yes.
So the issue that was decided in this decision is in paragraph 5.
Paragraph 5. issue for our consideration.
Right.
It begins that way.
Yes, but the question of law.
Confusing paragraphs.
5.1. Issue for our consideration.
We cannot make a reference to the will for this not registered intersection. That is the question.
Yes.
That is answered there.
Answer there.
The question is articulated.
Kindly turn to
yes.
So paragraph 12. How their lordships have dealt with the matter?
No. If they have declared a law,
sir.
No, they haven't.
If under 141, if this is the declaration of law, then that is binding on us.
That's right.
Conclusion is at para 29. Reference to a larger bench.
The reference is something different. Finding is there, then reference. I'll take your lordship to that. I'll take your lordship to that.
No.
The finding analysis that has been made in different paragraphs.
Recorded the finding to be conclusive and as the law. Where was the need for referring it to the larger bench at all?
The reason being, referring to that Vaishno Devi, Vaishno, what is that?
Vaishno interface.
Vaishno,
your reference is made to the larger bench.
Right.
Under the Supreme Court rules, applicable rules. When the law is not clear, or law is contrary to law, the ratio of a decision is contrary to other ratios.
Correct.
Only then. Now, or it feels that it should be decided by a larger bench.
Right. But they have also taken note of that.
Yes. But one thing which Mukherjee says appears to be sensible, because whatever is stated in this decision cannot be taken as the law declared at all. If law was declared, where was the need for referring it to the larger thing?
So law has been declared. They say that the decision taken with the other two decisions, Silpi and Vaishno, is not the correct law, but they didn't commit because of the same bench. And therefore,
no law is declared.
No, law has been declared.
If law was declared,
right,
why it would refer it to the larger bench?
Larger bench because two other decisions are there which they did not agree.
Therefore, there is no law declared. Kindly see 141, how it is structured.
Kindly look at the reference manual.
Yes. Now, the fact that this is referred to the larger bench.
Yes.
That judgment does not decide the law.
After arriving at a conclusion.
No, it cannot be. Conclusion is matter should be referred to. That is the conclusion.
So kindly have a look at the reference.
Page number?
Page number 42.
Before your lordship, may I request your lordship to also see para 19 first.
I'll
para 19 and then go there.
Give the context.
That will give the context.
There is one famous judgment of the apex court. In what circumstances the apex court refers the matter to the larger bench? That has to be kept in mind. Because in a bit different way, of course, Rupert Cross treats it, even Solomons with Fitzgerald edition and 11th edition by Glanville Williams, Solomons jurisprudence. 11th edition is by Glanville Williams. He has stated that. But now 11th edition is not available. We have 12th edition, Fitzgerald's edition. Fitzgerald does not go to that point, but he discusses when the House of Lords overrules its decisions in that context, it decides that some aeroplane versus so and so. I do not remember. I'm telling it from some time ago. I had read that. Therefore, but there is one judgment of the apex court.
Para 29.
No, one decision of the apex court which says in what circumstances
that's
cases
right.
are referred to the larger.
I'll find out. I've taken note of that. I've taken note.
Because a case is referred to the larger bench, premeditates, that ratio is not discernible, and law is showing its face in mask, to use the words of Jeremy Bentham. When law shows its face, law or the president shows its face in mask, then to uncover the mask, it's one of the grounds for reference to the larger bench.
Yes.
Mukherjee is marvelous.
We'll do one thing, sir, but
Yes.
I'll
Continue on another thing.
Requires some consideration. Mr. Mishra, referring to NBCC, submits that certain conclusions have been drawn by the apex court, even whilst referring the matter to the larger bench, and that such conclusions constitute law declared under Article 141 of the Constitution. However, Mr. Mukherjee repels that contention, saying that the question of reference arises only when law is not declared. And that if law is declared, where is the logic in referring the matter to the larger bench? Father. I'll post it for tomorrow for further hearing, so that I may not forget what all you have argued. Which date you want to answer?
To match your lordship's
queries.
A little more time.
No, that may not be. It can be lawyer's judgment.
At least
But
as
you can
far
use
as I can say for myself, that your lordship's erudition, in front of your lordship's erudition, it's
a very interesting case where we cannot jump to any conclusion so fast.
But the questions actually, if I can get a copy of that, so that I can answer to your worship.
these are your lordship's orders, or
No,
it's
these are my notes, but I can share my notes with you. After all, there is nothing official secret.
Exactly.
No, your lordship has been dictating. We would also.
And that's just there for my reference.
We should also.
That's very good. Correct. No problem. After all, it's a participatory process. There is nothing to hide.
So that will be easier for me to answer all those questions.
Correct. I agree with that. Just take print and refer to. They are not well articulated.
The very fact that your lordship takes note of a particular point in a particular manner, whether it is the manner in which we would like it to be presented or we would like it to be altered, that also we can assist your lordship.
Well, one point is there, but the government has to answer, in fact. Because the tribunal, they are appearing for the tribunal. I'm a private party. So they can only explain under what circumstances.
But apex courts say you should not impede the tribunals at all.
No, it's not
maybe one case where, because the
earlier 2001 Supreme Court says that tribunals should not be impeded as party.
At all. But in such matters, it may be required because of such contentions. But actually, instead of tribunal, you should have made members of the tribunal parties. Then it would serve the purpose. Otherwise, very thick. Because tribunal, it is the what is that? Tribunal.
We can do that.
But there is one judgment, two judgments of the House of Lords, where the tribunal comprised of 3 members. And one of them was dozing when hearing was taking place. The House of Lords set aside that judgment, saying it was not tribunal at all because one judge was sleeping.
Because even if that one person gets...
This is number one.
Yeah.
Number, this is a...
No, here, my lord, what will happen is if that one person, 3 persons have signed it. 3 persons have signed it. If that one person goes out, it becomes again an invalid order because it has to be uneven number of members, odd numbers.
Decision, I am telling you.
Yes, please.
SP Sampath Kumar versus Union of India, 1987 Supreme Court. There they have referred to House of Lords judgment. Sampath Kumar is no longer good law. After 97 Supreme Court.
Yes, Sampath Kumar is no.
But there are rulings of the House of Lords where Sampath Kumar has referred to. I'll also just do my research. I have no other job than reading and doing this exercise, etc. Yes.
Can the state get it?
State is Mr.
Only point, Mano. So far the 123 page is concerned. Out of the 3 members, 1 person has been changed while the judgment was pronounced. On what is the contingency that 1 person has been changed, that can be clarified by the...
Not exactly.
We will assume the other person is dead and gone. How it improves your case?
It's maybe...
Because it is no longer the tribunal is Mukherjee's contention. Right? Means ABC. ABC. If ABC is the composition and alpha, beta, gamma are the persons who make the award, then where is the award? This is contention.
So there are judgments which says that here the designated authority is the person, third person. They get transferred or retire.
Correct.
Another person joins in his place.
Correct.
But here
he has heard the matter.
Sir, I'm giving an example. The court hears the matter, judgment is dictated.
Others can sign it because once it is dictated, judgment is there.
Exactly that
but that's not the case.
So I think this is the case of that time. Here the hearing took place, judgment was delivered, signature was made by the succeeding person. Maybe
that is not the case. That is not.
Well, that he has to explain that.
Because all the persons and party to this court.
Now Mishra is saying that you should make out this point.
So then maybe it might have happened.
In that way, nobody can in the bar compete with my learned senior Mishra.
So you can check up that.
That I can check. At what stage this contingency arises that another person came in the picture.
I cannot.
And this can be well answered by the parties also, those who have regularly appearing before the...
Therefore, always in English law, the writ court will always call for the records.
Yes.
Sir.
To see where is the actually cancer, where the gangrene has developed. That's the right way. Otherwise, you will argue one thing, he will contradict it. He will say, I do not know who is correct. Then where the judge should go?
Right.
Here,
he has to see the record.
Here the LCR can also be called for because it is at Cuttack.
In the meanwhile, the original LCR to be called for with lightning speed. Since matter is heard appeal to.
It is fixing to.
Which date?
A week after.
Week after.
Some date you can choose so that I can see whether my calendar is good. It will be that day.
16th, Millard? 16th?
Well, 16th we'll try. But come with written points.
The questions were given.
Yes,
I'll answer each and every question. Except that one which I cannot answer.
I will do some embroidery work to my dictation.
Right.
Then I'll send it to you. We'll send it to you.
Oh.
When the next item is mine, that is only my development work. I have developed a project because of certain regulation, certain notifications that was stopped. Now that embargo has gone, so it can take care of. That is, well, I have to develop.
Your friend is also.
BDI is a party, my lord.
Interim order to be interim order to be executed.
Interim order to be.
My
lord, item number 60.
Yes, I can, for the opposite party, my lord, he can say, so it may be taken up to court. At least.
Yes, sir.
My lords, may I submit one thing, my lords, that my lords, the law, my lords, the rule, my lords, by basing upon which it was rejected has been amended. So this application needs to be, my lords, re-examined at the level of BDI, my lords.
So case for remand. Case for remand.
Case for remand for reconsideration, or remand, my lords, for re-examination in light of the, my lords, amended law.
Can I make that order?
Yes, my
You
lord.
have the amended, both you are submitting like this. Both the sides.
Because the rule, my lords, Odisha Development Authority Planning and Building Rule, my lords, 2020 has undergone amendment. Earlier, there was a restriction that you have
21 or 22 amendment?
20, the amendment of 25 minutes.
25 amendments.
Our rule is 20.
See that serial number.
Serial number is 45.
Petitioner has scripted his prayer as under. Next paragraph. Both the sides very fairly submit that the so and so rules having been
That is there, that
amended in 2025, comma, matter be remitted back for consideration afresh, keeping open all contentions. First, ordered accordingly, and petition is disposed of. Okay, after passing the impute order.
My lord, kindly give it to me so that I can, my lords, I can highlight it so that it will better to refer.
Last item, my lord. Last item.
All better after two.
Item 54. Item number 62, my lord. 1 minute. Yes, my lord.